Why don't you go see your boyfriend?
Yeah, he got a nice room. You won't have it long. He left a call for 7 a.m.
See if we can figure out something.
This is what I do.
Hi, it's Monday. There's a sleeping Winchester behind me. Morning, Steve. Well, afternoon for me, but afternoon, Lilith. How is everyone doing? Hey, Britta. I am very excited for this thing I'm going to show you. However, we know that YouTube takes a little while to tell people that I'm live. So I thought we could watch some of Judge McBurney with the sovereign citizen turned pro se from the Airbnb trial before we go to this thing I found that, by the way, I have not seen anybody else cover or even know about it. So I'm excited. That is a saw because I pulled the skin. That's good, Lilith. I'm glad to hear. I hope people had an okay weekend. Hey, Lisa. On Friday after dance class, we saw and were almost part of an accident. Drunk driver, but I don't want to go into it because I just literally had a therapy session this morning and I finally stopped remembering all the things so vividly. So, okay, let's do this.
Change. Yeah, that's why it's going to be delayed through Zoom.
Where does this start?
Judge, are you ready for the media? They have the Rule 22.
Sure, they can come in whenever.
Okay. Thank you, Judge.
Yeah, I need to bring Pritchett in and see what we're going to do. So I'll see you in a sec.
Joanna, is this the HDMI we can use for the system? Is it connected to your system, or do we have to run that black cord all the way over here?
So what people typically do is play through Zoom. I'm not sure what you need to hardwire anything to. So if your machines join the Zoom session, then if you've got an image or whatever, a PowerPoint, that should appear on all the screens because you're sharing your screen. And you don't need an HDMI, it's just through Zoom.
Okay.
This is Robinson.
No, it's still.
All right, let's get on the record in State versus Robinson and Pritchett. We have our prosecutors here in the courtroom on Tuesday, the 23rd. Ms. Mignot and Ms. Blake are here with their client, Mr. Robinson, who looks like he got a haircut. Is that correct?
You got a haircut, Judge.
Thank you. Are we satisfied? I mean, is it okay for Union City standards? Okay, great. I'm glad that worked out.
Thank you, Judge.
Thank you. You're welcome. I just asked. I didn't do it. I think we are good to go.
By the way, yes, Psychosaurus is the accused. And you know what? I landed up absolutely rooting for him. When I watched this, oh gosh, I couldn't believe it was the same person. He did so well. Hey, Bob. Meetings start with the arranging of the cables. All good meetings start with the arranging of the cables. Lilith, it is, I just turned off the boost as well, but the judge's mic is too loud on his side.
With Mr. Robinson, there may be a few things we need to talk about. What I'd like to do first, though, is bring Mr. Pritchett out to see if he's going to join us this morning. And then we'll take up anything we need to discuss outside the presence of the jury. So if you all could bring Mr. Pritchett, make sure that chair's available for him just in case he chooses to sit. It looks like it's right there.
Hi, Lisa. Not Lisa Dramalama, other Lisa. Well, Lisa Dramalama, I'm not saying hello to you, but I said hello to you already.
Thank you. My copy? Yes, thank you, sir.
We're good except for that one. Okay, thank you. Thank you, sir. Okay, we'll do that whenever we can. Thank you. All right, good morning, Mr. Pritchett. It is the start of the trial. We've got our jurors and they are about to come in. I wanted to check with you this Tuesday morning to see if you had had a change of heart and wanted to engage meaningfully, constructively, and non-disruptively and participate in your trial. Any update from you?
I'm not here to say I'm here in proper personas to jurors under the rest of coercion. I am not here as the legal name or legal person, Max Pritchett, that the state in this court has against my presumption of innocence, presuming me and forced me to be. I'm here in my private God-given Christian name, which I do not consent to being used for any commercial purposes in this courtroom. Furthermore, that the record show I do not understand the nature and cause of the proceedings and claims against me, nor do I understand the nature and authority of this court. How can I possibly understand these things and participate properly in this trial when the court has failed to disclose what jurisdiction they are operating under? The court has arbitrarily assumed personal jurisdiction over me by forcing me to be the legal name and person Max Pritchett when there has been no evidence proving such claim that I own that name or ever consented to that name on record. The court has denied my presumption of innocence in regard to those elements of the charges. The court has also prejudiced me by declining my request for full disclosure of the discovery that shows the evidence proving all the elements of the claim and charges against me, so I can prepare a proper defense.
Okay, Mr. Pritchett, Mr. Pritchett, I'm gonna stop you because everyone in here has heard this now a bunch of times. Nope, you
Continue to make the record for the violation of the rights.
tell me how much more you have, because if you've got 30 seconds or less, you can. Otherwise, you continue to disrupt these proceedings by repeating baseless allegations about lack of personal jurisdiction and these things about improperio personam. And you've made a record of that a whole bunch of times. We don't need to remake the record. But if you want to spend the next 30 seconds adding what you want to add, then I've got a couple questions for you. If you want to answer them, great. If you don't, then we'll check in with you during the morning break.
Okay, let the record show that the court has stated I can only see the full discovery only if I have an attorney. The judge of this court has practiced law from the bench by entering pleas on my behalf against my consent. I have been greatly injured by this court and state that I cannot properly participate or prepare a proper defense in light of these due process violations and the impartiality shown toward me. Mr. McBurney, are you prepared to rectify these issues and help me understand the full nature and quality of the claims and charges against me, along with the nature and authority of the court? If you cannot do that at this moment, can you please recuse yourself from the fact that your impartiality?
Hold on 1 second.
bias toward me?
Okay, I'm sorry. Ms. Mignot was adding a machine. It was creating feedback, but it stopped. So keep going.
Again, I just want to repeat, Mr. McBurney, are you prepared to rectify these issues and help me understand the nature, the full nature and cause of the claims and charges against me, along with the nature and authority of this court? If not, can you recuse yourself from the fact that your impartiality and bias toward me have been brought into question?
All right, thank you, Mr. Pritchett. I think that it's important that the record reflect that the issues that are being prosecuted in this case are things with which you're most familiar, since you represented yourself at your revocation hearing in your other felony case, and the basis for your revocation in that case were the facts and circumstances of this case. So I am confident that you're familiar with the allegations. We've already discussed that. And when you were represented by counsel, you had full access to all the discovery, including discovery that you may not possess as an inmate at the county jail. When we had our discussion about you representing yourself, okay, well, we have differing perspectives on that. Regardless, this is an opportunity for you to join the proceedings. Do you care to sit?
How can I possibly participate properly if I don't have the evidence of all the evidence against me? You're not allowing me the opportunity to even understand the full nature of the cause and the authority of this court.
Well, I am by inviting you to join us for these proceedings, but you're declining. You don't want to sit and you don't want to engage in the way that someone who is meaningfully participating in the trial would engage. So I find once again that because you're unwilling to follow the basic rules of decorum in the courtroom, that I'm going to excuse you. I'll bring you back out in the next break. And if you want to participate, you remain welcome to do so as your own advocate, which is what you requested last week and is what I granted you. So, Deputy, if you would remove Mr. Pritchett from the courtroom, we will try again later this morning. Mr. Hiles, is there anything we need to discuss from the state's perspective before we bring in the one juror?
I just want to put on the record that I did provide all parties with an exhibit list, and I do have an extra copy for Mr. Pritchett. I just want to make sure that I'm bringing everything for him if he would like to participate, making it available for him.
Great. If you don't mind putting an extra copy over there where Mr. Pritchett is invited to sit every time he and I have the same conversation, I'll make sure that he picks it up and adds it to his collection of papers that he brings out and reads from to tell us about whether we can use his God-given Christian name or not. Anything else from the state?
That's all I have.
All right. Ms. Mignot, anything on behalf of Mr. Robinson?
Good morning, Your Honor. Yes.
Good morning.
This morning, the state was kind enough to go through the exhibits that they anticipate presenting in their case in chief. And I have a concern about at least one of the exhibits.
Which one is that?
Exhibit number 16 is a picture of shoes. And throughout the pendency of this case, there has been no discovery provided to our firm. And I want to be clear with the court, we didn't just go to previous counsels because there had been several. We provided the state with the terabyte, 2 terabytes, however many terabytes they requested. And they assured us that all the discovery that was in the states, that the state intended was associated with this case was produced. There has never been a photograph of any sneakers. There have been mentions of photographs of sneaker, but there has never been any. This morning, Mr. Hiles advised me that one of the victims or the alleged victims, Mr. Chris Riggs, produced last night the picture of the tennis shoes that's depicted in Exhibit 16. And I have concerns, and the reason I have concerns is because we are now, as defense, unable to do any type of investigation of when that photo was taken, to get any type of IT person to go in to make sure that it wasn't produced at a different time than it said it was produced, looking at a cell phone, any forensics associated with that photo. So now my concern is, we're here at trial, we have a jury ready, and we've mentioned sneaker, 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 and there's been no evidence presented about any sneakers, and boom, voila, trial by ambush, here's a picture of a sneaker that we're intending to show a jury today. So we would object to Exhibit 16. As it pertains to Exhibit 19 and 20, Judge, we do have that in discovery. However, my concerns is it's a different address from the incident address location, and it may create confusion for the jurors as to which house are we actually talking about here as the Airbnb house.
Okay,
And-
but that may be, should the state seek to admit it, a relevance objection. It's not a, we've never seen it before.
Correct,
Okay,
that is correct.
all right, so I'm going to table 19 and 20. We need to see the context in which it's presented. It may be relevant, but maybe it's a 403 because it's unduly confusing. But I appreciate you flagging that. Can you get Exhibit 16 up on the screen?
I have it for you.
Okay, great.
So, Your Honor, this, and it mentioned also discovery, this is something, it's a picture that we had at the beginning, it was turned over with the original file. This case has been going since 2019. At some point, I did lose part of my file. We had issues with the game server. So it may have very well not been turned over to Ms. Minot. And last night when we met with, it's actually Jackson High, that was not with Christian Riggs.
Okay,
Those are his shoes that were reported as being stolen off his feet. He has it on his phone, so maybe if the defense would like to see when the picture was taken, I don't know if it's still got that data, but it's a picture of the shoes taken, he bought the shoes the day of the robbery.
okay. So the way you would use states.
Okay, so we're gonna skip all of that. We're gonna go to the next time he appears.
You are in control of this when I am up there.
Yeah, it's not it's a shot, but it's two of it.
Oh, you're back.
Yes,
I was
sir.
like, why are we just waiting around? Okay, let's try one more time with Mr. Pritchett, just so we're making a good record. Please.
For sure, I'll get the individual one. Little photo.
Morning sheet to your right hand, there's four different options. The one that looks like almost like this computer. It has a little.
I need to give you something to throw at me in case I'm not speaking loud enough. Yeah. Just let me see. Okay, well then we'll call her first.
Sure. It's fine, they could do that one. We don't move,
But I think you're right.
But it does not.
Yeah.
It's a little difficult
I
to do.
think we'll play it through Golden like you said.
we don't move it now.
I think it's better. I know. It's a good call.
We're back on the record in State versus Robinson and Pritchett. Mr. Pritchett has been brought back into court. Two things for you, Mr. Pritchett. There is an exhibit list from the state, and then some family member of yours brought a document that she said you wanted. So that's the second piece of paper. I want to make sure you add those to your collection. And I want to know, again, if you would like to join us and participate. And yes, you're on the record.
This is all discovery.
I've given you an exhibit list and a document that a family member of yours wanted you to have.
On the record, Mr. McBride, before you were a judge, you were a lawyer. Before you officially became a lawyer, you signed a title of nobility. How can this court lawfully move forward if you're not even supposed to be on the bench and according to the Constitution, you are no longer a U.S. citizen?
That's an interesting question. I didn't know I had a title of nobility. Maybe because of that, I could retire early. But for now, I'm going to stick with the title of judge and ask you if you'd like to sit or if you'd like to go back to lockup again, and we'll check during the lunch break if you want to rejoin us.
I will sit down, actually. I just have to understand what jurisdiction is this court operating under.
The jurisdiction of the laws and the Constitution of Georgia and the United States. So what's going to happen, should you choose to sit down, is the jurors are going to come out. I am going to swear them in and give them some basic legal instructions, and then it will be time for folks to give opening statements. You will have an opportunity to give an opening statement if that's what you want to do. When it's your turn, I will address you. It would be real helpful if you would tell me the manner in which you would like me to address you so that I don't get you upset by using a title or a name that for purposes of this proceeding you seem not to like. Are you prepared to answer that for me?
Yes. Can this court first take judicial notice that I am not the legal name or legal person, Max Richard?
I cannot take judicial notice of that, but I would love to know, I'm gonna write it down, how you would like me to address you when we've got the jury in here.
Why can't judicial notice be taken of that?
Because that's not the type of thing for which judicial notice can be taken. Judicial notice can be taken of records in the court's docket, of non-arguable things like today is Tuesday, or when the sun rises, the sun sets, things that are incontrovertible.
That's an arguable claim that I am the legal name, person, Max Richard.
That's not what you asked me to take judicial notice of. Why don't you repeat that?
You said that I couldn't take, that the court couldn't take judicial notice of it because basically it's an arguable thing, and it's not an incontrovertible thing. I'm asking.
I thought you asked me to take judicial notice of the fact that you don't go by the name Max Pritchett.
That I'm not the legal person, Max Pritchett.
Right, and that's not something I can take judicial notice of.
That's a fact, and that it is an incontrovertible thing. Why can't you take judicial notice?
Because it's not. And that's not what we're here for. We're not here to litigate by what name you want to go. I'm showing you the courtesy of asking the title or name by which you would like to be referred while the jury's in here. If you want to answer that, that's great. If you don't, I'm going to refer to you as Mr. Pritchett. That may get you spun up in front of the jury. That generally doesn't help you. But if you want to tell me now, great. If you don't want to tell me now and don't want to sit down, we're wasting the juror's time again to accommodate you making this record about who you are or who you aren't, jurisdiction, admiralty, and things that actually don't have a bearing on what we need to do today and the next day and the day after. So tell me by what name or title you'd like to be referred.
I have an answer for that. I just have to make sure this court recognizes and understands the fact that I am not the legal person and legal name before me.
I don't recognize that, but I'm willing to refer to you by whatever name or title you would like.
So you're forcing me to be that.
I'm not forcing you to be anything. I'm just not recognizing something you want me to recognize. I don't force you to do anything. I am not recognizing the thing you would like to be recognized. In the same way, Ms. Mignot may have an objection. I may overrule it. I'm not forcing her to do anything. I just have disagreed with her.
Why is this court recognizing me as being the Max Christian? There has been no evidence to prove that I own that name or claim that name as personal identification or the sentence that they will work.
There is evidence of that. I don't know that it will necessarily be presented at trial, but we don't need to get through what the fingerprints show, your fingerprints are linked to, et cetera. But I'm pretty comfortable that Max XX Pritchett is a name that's associated with the guy standing in front of me with the red jumpsuit. Nope.
Claim that's being made, I have the right to see.
Okay.
See the evidence.
That may be something that you want to argue. I don't present evidence or anything like that. The state does. So, all right. You've got 3 seconds to take a seat. If you choose not to take a seat, we're done this time of the merry-go-round, and we'll have you go back to lockup. You're going to take a seat?
Just before I take a seat, just to clarify, that you are avoiding the claim and the evidence of why you're claiming to be that legal person next to Richard. I'm gonna clarify the jurisdiction you said it was, jurisdiction of the state of Georgia. I just have to make sure you clarify something that the Constitution speaks of 3 jurisdictions, again, yesterday, which are common law, equity, and morality. Which of these jurisdictions will operate?
We're done with that conversation. Do you want to give me a name or title you'd like me to use?
So the jurisdiction is not constitutional, is that what you're saying?
Mr. Pritchett, take a seat, please, or I'm going to ask the deputy to send you back to lockup. Okay, if you take him back, please. Because you didn't give me a different name to use.
Because you're still recognizing me. If I give you a different name or not, the court is still recognizing me as something that I did not.
This is a great opportunity to take a seat. Going once?
I'm still trying to understand the jurisdiction of this court.
Okay, well, I'm going to give you an opportunity to think more about it back in lockup, and we'll check in with you at lunchtime.
So the court is labeling me as disruptive because I'm not taking claim to something that they're forcing me to.
No, I'm labeling you as disruptive because you won't sit, and you won't tell me by what name you'd like to go.
So for the people just joining, we watched this trial over on Recovery Addicts channel. It was the Airbnb trial, and he landed up being called the accused. But what I wanted to show is I loved how Judge McBurney dealt with him, because you see how he's being so firm, and then it's like slate wiped clean. He treats him with respect, and I just want to see if it's in this on this day that he comes back.
She is officer, right? She has a different last name. She had,
You were Officer Wright originally, 7393?
Yes.
Excellent. Were you the first responding officer? And back then you were right?
Yes, sir.
Okay.
Now I'm wrong.
To talk about whatever you were going to talk about. So we're going to state our process. We need it out, and we can try again to see whether he wants to join us.
I'm gonna take this from you.
Ms. Mignot, did you figure out if that cable 1 reaches and 2 connects in the way you need it to connect?
Your Honor, I did everything. I was sufficient and I'm ready to rock.
Excellent. Glad to hear that. Good afternoon, sir. We are on the record, and I wanted to chat with you again to see if you have decided that you want to join the proceedings. Are you prepared to take a seat and let me know by what name you'd like me to refer to you when I introduce you to the jurors?
No, at no point do I waive any of my rights. That's it.
Okay, I'm not asking you to waive anything at all. As you know, my default has been to refer to you as Mr. Pritchett. That's how you've been introduced to the jurors in terms of a name. Is there a different name or title you'd like me to use when I'm turning to you? For example, with this next witness, Officer Weems, when she's testifying, the state's going to ask her some questions. Ms. Mignot may ask some questions on behalf of Mr. Robinson, and then you'll be entitled to ask questions if you want to. You're waiving nothing, and you're obligated to do nothing at all. But at some point, I'll turn to you, and I need, for the record, to say Mr., and I plan to say Mr. Pritchett, but I don't want to say that in a way that causes you to become agitated or frustrated or feeling like somehow your rights are being compromised. So again, my default would be to refer to you as Mr. Pritchett unless you tell me now by which name or title you'd like to go.
You can refer to me as the accused.
Okay? I think I can make that work. If it becomes unwieldy, then I'm gonna ask you for a substitute, okay?
Can you let the jurors know that by default you made a mistake by referring to me as Mr. Pritchett?
Nope. When you are given an opportunity to address the jury, which you'd have in your closing argument, because you elected not to be here during opening statements, you can talk to the jury about your theories and views of names and identities and all that. But so you're not surprised or confused, I'm going to explain to the jury that Mr. Pritchett has decided to join us, and he has asked that I refer to him as the accused from here on out, and then that's what I'll do. Okay?
Can you just refer to me as the accused? Can you leave the Mr. Pritchett part out? That is not something I ever went by.
Okay, and you'll be given an opportunity at the appropriate time to share with the jury your claim that you've never gone by the name of Max Pritchett. But I've told you how it's going to play out. I have to explain to the jury who this gentleman who is appearing in the middle of trial is, and then I'm going to explain that you've asked to be referred to as the accused, and from that point forward, that's exactly what I'll do.
You should let them know that I believe that there has been a mistake as far as the court referring to me as that legal name.
I'll fashion something along those lines, okay? All right, let's bring the jury in, please.
Okay, so from here on out, he is referred to as the accused, and the judge is so incredibly patient, understanding, respectful. And by the end of this trial, I'm not going to give away anything that if you want to go watch it on Recovery Addicts channel, I'm not going to give anything away, but I actually want Pritchett to go into law. I think he did phenomenally. Okay, so let me just get this.
Why?
Okay. So basically, I was just hanging out on YouTube as I do, and this small channel with these videos popped up, and I was like, okay, interesting. And then I went and watched a bunch of them and realized that this is like there's some sort of Telegram group, and people are being directed here from the Telegram group. And it sounds pro se for a large part, but for those of us who have watched a lot of Sov Cit hearings, you're going to pick up the parts where I'm like, I think you're a Sov Cit. I think you're going there. So this guy's name is Kurt. We'll hear his surname when, Kurt Benshoof. That's his surname. And this is a bunch of different hearings that I've put into a playlist. I am going to, hey Sim, and hey Helena, and Teresa, I'm going to set up the cat cam because the babies are sleeping here. So I'm going to be out of the room for a minute. I also need to grab lunch, and then I need to be putting my head down for a bit. But I will be listening, of course, and you'll know exactly what I think.
Okay.
Oh, also for the people who weren't here at the beginning, I haven't seen anybody else cover this. So I've just gone right in because I didn't want to waste time watching it first myself in case it was being recommended to everybody everywhere.
Not a problem, of course. Courts are open to the public. You're welcome to observe, just as long as you're not disruptive to proceedings or nothing. Perfect. Not a problem. Thank you very much. I'll go ahead and get Judge Blair now. Again, we'll get started.
That ding dong sound stops. It's just for the beginning when people are joining.
Thank you. That's a little bit.
Make sure you keep an eye on the right-hand side before they start. It is the defendant person typing these messages. Wait.
For the beginning session, the Honorable Mark Blair Naga presiding. Your Honor, we are back on the record in matters of Benshoof versus City of Seattle, cause numbers 2323749-8, 232-23752-8, 232-23761-7, and 232-23764-1. All Seattle designation. Parties, please introduce themselves, starting with plaintiff.
Good afternoon, Your Honor. This is Kurt Benchoof, plaintiff.
Good afternoon. Good afternoon, Your Honor. Dallas Appeal on behalf of the City of Seattle. Good afternoon. Mr. Benchoof, thank you for, apparently I was mistaken in believing that the matter was this morning, but it was noted for 1:30. I don't know how there was a miscommunication on our end, but regardless, you're here. Mr. LaPierre, thank you for actually bringing it to my attention. And so I have read the materials. There are 4 different writs. Mr. Benchoof, how much time do you think you need for your argument? There's 4 of them. What I would like to do is to kind of go each one at a time instead of cross-pollinating them. Would 15 minutes be sufficient?
Well, Your Honor, it partly depends upon whether Mr. LaPierre is willing. But
I'm sorry, you cut out on me there, sir. It depends on what?
You missed my joke. I said it partly is predicated on whether Mr. LaPierre concedes the city has no defense. But if I could
let's just assume that doesn't happen.
If I could request 5 minutes for each case, so 20 minutes total.
That's perfectly fine. And then, Mr. LaPierre, well, let me ask you this, Mr. Benchoof, and I'll ask you the same thing, Mr. LaPierre. Do you want to do your 5 minutes and then have Mr. LaPierre respond to that, or do you want to just do all? That makes sense. The easiest way for me to manage it, but I can do one at a time.
Well, if we don't want to cross-pollinate, then it might be easiest to take one case at a time.
Let's do that.
Okay.
Mr. LaPierre, you're okay with that? Yes, sir, I agree. All right. Let's start with the the case ending in 498. Do you have that, Mr. Ben?
Yeah, that would be 232-237-49-8, which relates to Seattle Municipal Court case number 656748.
That's correct. Let's take that one.
Okay.
Whenever you're ready.
Yeah, so, Your Honor, it's quite a simple process what happened. The PCC employees asserted their mask policies were laws. I informed them repeatedly. I tried to explain to them that they were not laws. The store employees handed me civil trespass admonishments. I explained to them that that's a civil matter, that they were welcome to bring civil suit against me if they believed that they had a valid cause of action for civil law trespass. And I informed them that by denying me, based upon my creed, the full enjoyment of their public accommodations, that they were violating RCW 9.91.010, denial of civil rights, a gross misdemeanor. They refused to concede the point, despite me trying to talk to their general counsel. Step 3 was they brought in the police department. I explained to SPD that they didn't have criminal jurisdiction over a civil dispute. They refused to comprehend that basic fact, and they took that civil trespass admonishment paper and magically stated that they had criminal jurisdiction over a civil matter. At which point, I was unlawfully imprisoned when every time Seattle Police Department officers forced me from the store, because under RCW 98.40.010 subsection 3, restrain means to restrict a person's movements without consent and without legal authority in a manner which interferes substantially with his or her liberty. I was unable to grocery shop. That was a substantial interference in my liberty. Sorry, I'm making sure I don't lose power. And the police department asserted that whatever words they spoke magically had the authority of law as a quote-unquote lawful order. But we know from Ham v. City of Rock Hill and a Washington State Supreme Court case, City of Seattle v. Rice from 1980, which specifically addressed the vagueness doctrine relating to a lawful order. I think we can all concede that the police officers were violating that. After the unlawful restraint, then the City of Seattle's next step in leading organized crime was to violate RCW 35.20.270 subsection 1, which Mr. LaPierre's fellow employee, Katrina Outland, a prosecutor, has already declared to the court that the city's policy and widespread customs is to mail out summons of criminal process, which is a violation of that law and a violation of official misconduct, RCW 9A.80.010. And despite Mr. LaPierre arguing that RCW 2.04.190, which specifically is titled Supreme Court, and states in part, the Supreme Court shall have the power to prescribe the forms of process to be used in all actions by, let's listen closely, Supreme Courts and district courts of the state, period. There is no provision in that statute by which the Supreme Court was delegated the authority by our legislature to confer power upon a municipal court, as it's not listed in here, by which the municipal court could violate RCW 35.20.270 subsection 1. And then the next step in leading organized crime was bail would be put out for my arrest. And, whenever the city has arrested me, they then engage in first-degree theft, RCW 9A.56.030, and felony extortion, RCW 9A.82.120, by demanding that I give them money to effect my release. So, the thing is I think it's pretty clear from the law in hindsight. I admit that there was uncertainty at the time, but there was never a law by which they could force me out of a grocery store simply because I wasn't wearing a mask. Do you want to tell me how I'm doing on my 5 minutes so I don't run over? You
have about a minute.
Okay.
What I would like on all of these, but right, since we're on this one, I would like for you to tell me exactly what you're asking me to do.
Okay.
I read your pleadings, and they're well drafted. But so I don't really need for you to take too much time on the history, factual history, unless you think it's you need to do it to tether it to a specific issue or legal point. But what I would like on all of them is for you to, at the end of your summation here, is to tell me exactly what you're asking me to do. What specifically are you requesting?
Thank you, Your Honor. Specifically, through the writ, I am seeking a court order, I guess it's also called a writ in this case, which prohibits the City of Seattle from continuing to maliciously prosecute me in violation of RCW 9.62.010 for these 4 criminal trespass charges. Because the city police never had criminal jurisdiction, the courts never had personal or subject matter jurisdiction, and these have been maliciously motivated. Well, I mean, it doesn't even matter what the intent was. I never trespassed in any store. There was never, trespass in the first degree requires that I had to have been in the store unlawfully. And there was no one could ever provide me the explanation of how I was in the store unlawfully. And, I talked to the King County prosecuting attorney's office clarified for the sheriff's department that I was following the law, and I don't know how. Yeah. So in summary, I'm just asking the court to prohibit the malicious prosecution of me, Your Honor.
On those trespass matters.
Yes, Your Honor.
Okay, thank you very much. So up here?
Yes, Your Honor. I think the question and issue, Your Honor, is very narrow and under a writ of prohibition. It is, did the court act in excess or in absence of jurisdiction? And is there a lack of a just, speedy, and adequate remedy? And in both of those, I believe the answer is no, and the writ should be denied. The standard law is very clear that cities under RCW's 35.22.280 are authorized to pass ordinances with the general police power, including the power to control all disorderly conduct. And that under RCW 3.50.020, municipal courts have original jurisdiction over all criminal ordinances that are violated within the city's purview. Under that authority, the city passed their ordinance on criminal trespass, which is at 12A.080.040A. It provides that it is, as Mr. Benchoof has noted, a criminal violation or gross misdemeanor to remain on property or to enter onto property without the lawful right to do so, and it provides several defenses, one of which is that you've complied with all lawful requirements or all lawful conditions of entry. As Mr. Benchoof has noted, he was entering into PCC, which is private property. He was advised by the owner of that property that he was not permitted, he was not authorized to enter the property. So the property was not open to him, even though it was open to the general public. And when he did enter and refused to leave, the police were called. It was determined that there was probable cause that the city's trespass ordinance had been violated, and he was arrested. The court prosecuting that particular trespass charge, the 4 trespass charges, I believe, is acting firmly within their subject matter jurisdiction as laid out. Further, the courts had personal jurisdiction over Mr. Benchoof. The criminal cases was filed, and the summons and complaint of the criminal complaint was served upon him by mailing in accordance with the criminal rules of the criminal rules of courts of limited jurisdiction 2.2D2, which authorizes the court to mail postage paid the summons and the criminal complaint at the last known address of the defendant. So therefore, the court was fully within their personal and subject matter jurisdiction in this particular criminal prosecution, Your Honor. And the warrant for Mr. Benchoof's arrest for failure to appear is also within the court's sound jurisdiction, particularly in light of a history of a failure to appear. The purpose of a bail warrant for arrest is to ensure appearance of the defendant at the criminal trial. Looking at the second question, Your Honor, I believe it is also very clear that for any misdeeds or misactions or mistakes within the Seattle Municipal Court's criminal court, there is an adequate, speedy, and available remedy. There are the resort to appeals, and there are also the resorts to injunctions and declaratory relief, either at this court or at the federal court in the ongoing current civil litigation within the Washington Western District Court. So having failed either one of those elements makes denial of a writ appropriate, Your Honor, and here both of those elements are not met, so I believe the writ should be denied.
All right, thank you very much. All right, Mr. Benchoof, let's go to, yes.
Okay. I was just
Did you
going to
wanna do
ask if we could do a minute rebuttal.
Sure, yeah, how about a minute in rebuttal?
Okay. I think the most important thing here is that Mr. LePierre's essentially asserting that anything a store employee says is their policy becomes law by which they can then violate 9.91.00, which is absurd. And the example, of course, is if the KKK opened a store and said that they were all afraid of Black people coming in and said, well, that's our store policy, we all know that the Civil Rights Act forbids that, because when it relates to race, creed, religious belief, gender, they can't do that. So that's absurd. And the right to pass codes by the city is a red herring. I'm not challenging that. I'm saying that the enforcement of the codes was a violation. And lastly, as far as the remedy, I've already tried an injunction. The federal court said that this is a state matter. I can't even file a motion in Seattle Municipal Court because they say I have to subject myself to arrest before they will accept a motion, and the public defender refuses to withdraw, so I'm blocked from doing anything. Thank you.
So, Mr. Bishop, let me ask you a question. I want to make sure I'm understanding your, and I think I do, but I want to make sure I'm, in my notes, phrasing this accurately. Your claim here is, in essence, kind of using your analogy about the Ku Klux Klan owning a store, is that the PCC, I think it was a PCC if I remember correctly, violated your religious beliefs by requiring you to wear a mask into the store, and when you're exercising your religious beliefs and not having a mask, and then when they said to you that you're no longer welcome, and then subsequent no contact order, or are they actually no contact orders? What were the complaints?
Well,
What would they be?
there were two different no contact orders. After I was charged at the Aurora store, they put a no contact order in place, which I have respected for more than 3 years. There's
Right.
been no problem there. An individual manager at PCC Fremont obtained one for 2 years. That expired in April of last year, but the
Is it-
but there's
I'm sorry. So these are trespass claims. Sorry, my mistake. I think I commingled this. I may have conflated something. So on this matter, what I hear the argument being is PCC's required you to wear a mask for religious reasons. You won't wear a mask, and then when they refused for you to either enter or subsequently you did enter against what they're calling as their policy, and created these trespasses. That this is unconstitutional because of your religious. All of them are kind of under the basis of your religious beliefs.
violation of my religious beliefs, also known as creed under state law, is the primary objection.
Okay, thank you very much. All right, let's move to. I'm taking these in no particular order, but other than what's on my computer, let's go with the case ending in 752-8. This is in reference to Seattle Municipal Case Number 671384.
Okay.
Are you ready? Are you there, Mr. Up here as well? All right. You can just nod if you are.
Yes, Your Honor. All right.
Perfect. All right, Mr. Venture, let's go.
Okay. So
5 minutes.
in this case, there were several layers of fraud and lack of jurisdiction. And it initially started out with there being no domestic relations by which family court could assert jurisdiction under Title 26. And
Mr. Bishop, I'm going to interrupt you and I apologize.
Yeah,
Let's
just
work
go
backwards.
Okay.
Let's work backwards. I think I think, frankly, in all arguments, is to tell me what your specific.
imprisoning me under the warrant that's associated with this case.
Okay, thank you. All right. Now give me the basis.
Okay, I'll remember that for next time. So
That's fine.
the basis is there was never domestic relations, and without domestic relations, family court does not have jurisdiction to force both parties to be subject to parenting plans, because domestic relations is defined as a dissolution of marriage or domestic partnership, declaration of invalidity, or legal separation. I was never in any of those with the mother of my son. Parenting plans required domestic relations under RCW 26.09.004 subsections 3 and 4. Restraining orders issued under 26.09 require domestic relations under 2609.050 subsection 1 and .060 subsection 1A. The restraining orders issued in those cases, leaving aside for now the fact that there was clear evidence of not only foundational perjury by the mother of my child, but that there was extrinsic and collateral fraud involved. if we move over to RCW 7.105.310 subsection 5, it states a restraining order shall specify the date the order expires. However, Miss Owen, who's the mother of my child, her attorney, a family law specialist, was able to obtain a restraining order with two expiration dates, October 21st of 2022, or sorry, October 21st of 2023. That was one of the dates. And the other date was September 28th of 2027. That also violates RCW 7.105.315 subsection 2, which states if a protection order restrains the respondent, me, from contacting my son, the restraint must be for a fixed period not to exceed 1 year, unquote. And yet, not to mention, this is another violation of the vagueness doctrine to have a restraining order with two termination dates, but the family law attorney knew full well that when the clerk of court entered into the WACIC, the police would see on their screen the later of the two dates, and that they would enforce that upon me. So, on several grounds here, family court never had jurisdiction to issue the restraining order, and it was void ab initio because it violated the vagueness doctrine. And, I did everything I could to provide this documentation to multiple police officers, and they had a stated policy of not taking any complaints from me, which seems to have arisen from their civil liability going back to the original malicious trespass prosecutions. I had multiple police officers tell me to my face, we're not taking anything from you. We know you're trying to set us up. So, all I've done is speak the truth, try to uphold our laws, and ensure that we have equal protection, and love my son, who's my best friend, and, his mother, her corrupt attorney, and certain city officials have been running cover for this the entire time. And I would really appreciate if this court would, I think the court has a duty under its equitable jurisdiction to ensure that injustices such as this do not continue. And, more than for myself, Your Honor, this is for my son. He already considered suicide because of the prolonged estrangement due to his mother's perjury. And, my hands are tied to some degree until I'm not living in fear of immediate arrest and more malicious prosecutions. And just to preemptively address Mr. LePierre, he's going to object again and say, well, Mr. Benchoof should have tried an injunction. I already tried that in federal court. I've already tried habeas petitions all the way up to the United States Supreme Court. I've seen federal judges misapply federal domestic relations exclusion to refuse their requirement under 28 U.S.C. Section 1331 to do a jurisdictional inquiry into the family court proceedings. My son could die while we're arguing about this. Thank you, Your Honor.
All right, thank you. I do have one quick question for you, Mr. Benchoof. These arguments that you're making today, which are very direct and poignant, why couldn't these be argued at a trial or?
I'd be happy to answer that, Your Honor. The city
because that's why I asked it.
In this case, 671-384, the city didn't even mail me something. They immediately issued a $250,000 arrest warrant.
I read that, right.
There was no way. So I haven't been able to file even a single motion into that case and have it heard because they are forcing me to keep a public defender, which blocks me from filing anything. So unless I go get arrested indefinitely because I couldn't bail out, then like they're making me choose between, do you want your liberty or do you want to be able to be heard in municipal court?
I get it. I get it. Okay. Thank you. Mr. Lapierre?
Yes, Your Honor. And this case, again, is going to rest on the two questions of whether or not the court is acting in excess of its jurisdiction or if there is an alternative remedy. In this particular writ, we are looking at three different criminal ordinances that the city has passed. They are the stalking, parental interference, and violation of a protective order. The city council, in passing those ordinances, acted well within their statutory authority, as confirmed by the statutes I referenced earlier in the Abawashi case. And the Seattle Municipal Court has original jurisdiction over a violation of those criminal ordinances. So I believe the court is acting well within its jurisdiction. Dealing with the issue of the family court and whether they had jurisdiction to issue the original protective order that is the subject of this issue, the jurisdiction of that court is incredibly clear. Around the country, every state has passed the Uniform Child Custody Jurisdiction and Enforcement Act that determines who has jurisdiction to determine custody of children within the United States. The purpose of it was to ensure that every state follows the same rules, so there's no question over who has that jurisdiction, what court has that jurisdiction. There's no question here that Mr. Benchoof Mr. Benchoof, the mother of the child, and the child, the residents of the state of Washington for the 6 months prior to the initiation of the the custody action under which the protective order arose, and so jurisdiction within that court is well established. The protective order arose as part of the allegations within that and was well within the sound jurisdiction of the King County Superior Court, Your Honor. Not only that, there's also a protective order that was issued in Seattle Municipal Court as well. So there's multiple protective orders against Mr. Benchoof and his former partner. There is an allegation that there is some fraud in the obtaining of that particular protective order, the family court protective order, and that Mr. Benchoof has proof of that, and I don't doubt Mr. Benchoof's word. However, all the city has is a valid protective order validly issued by a court. There's been no effort to appeal it, no effort to overturn it, no effort to have anything done within the family court related to that, and there's simply no other injunction or other court order that overrules that particular court order. So we're kind of bound by that. As to the personal jurisdiction issue, again, Mr. Benchoof was issued a summons and a complaint in accordance with the criminal rules of courts of limited jurisdiction 2.2D2, which is appropriate and does grant the court personal jurisdiction over Mr. Benchoof. Looking at to the second question, which is whether or not there is an adequate remedy, Mr. Benchoof has remedies he could have sought and still, I presume, can seek within the family court, either appeals, motions within the Superior Court for injunction. He can also go to the federal court. In fact, there is currently a federal case relating to all of this pending in the Western District of Washington. We're at the motion to dismiss stage, so we haven't entered into the discovery stage, but that case does exist and offers an alternative as well, including injunctive declaratory relief at the state level. So, Your Honor, I think both prongs of the test for writ of prohibition not being met, this prohibition should be denied.
All right, thank you. Mr. Benchoof, do you have a brief response?
Yeah, Mr. Lapierre knows full well I already tried an injunction specifically related to this case before Judge Whitehead in federal court. Mr. Lapierre also has sworn evidence documenting with all of the exhibits the perjury. So Mr. Lapierre is being disingenuous to imply that the city does not have evidence in its possession of the perjury foundational to the collateral fraud. And he argues that I had options in family court. That's missing the point. I've asserted all along family court does not have jurisdiction, so I can't go argue in a court that already doesn't have jurisdiction. And I tried a motion to vacate. That was denied. I'm not a ping pong ball that gets batted around because I didn't file the right 9 motions in the right 9 courts. We're at a point of ridiculousness. Thank you.
All right, thank you very much. Let's proceed over to the case ending in 761-7. You let me know when you're there, Mr. Bencher. You ready? All right.
Sorry, I was on mute. Can you confirm which Seattle Municipal Court case that
Oh,
involved?
sure, absolutely. Seattle Municipal Court, or excuse me, Seattle Municipal Case Number 669329. Sorry, I should have read that.
Okay, yeah, thank you. So again, this is very similar. We don't need to cover all the same ground. It's very similar situation to the 671384 prosecution. The thing I'm requesting of the court, Your Honor, is that
Excellent.
the city issue a writ of prohibition arresting the city's malicious prosecution and ongoing attempts to detain, imprison, or me related to the associated arrest warrant.
Okay, thank you.
And as Mr. LePierre pointed out in his last segment, he asserted that there was a valid restraining order issued by Judge Gregory. And, you know, I was personally there on November 16th of 2022 when I started off the hearing challenging the lack of first personal jurisdiction because the city had violated RCW 35.20.270. The prosecutor, who was either Serafan or Outland, refused to provide evidence of the city's compliance with that. Mr. Gregory, Judge Gregory, asserted jurisdiction, and this is part of the racket the Seattle Municipal Court does, is they say, well, if we have territorial jurisdiction, if something happened within city limits, then we automatically have jurisdiction over person and subject matter, which you don't have to go to law school to know that that's ridiculous. You need all legs of jurisdiction for the court to be authorized to proceed. And in spite of that, in spite of me pointing out to Judge Gregory on the 16th of November 2022 that the city did not have evidence of a valid restraining order, and I tried to explain to them why whatever paperwork they had was invalid. They ignored that as well. The city prosecutor refused to provide evidence, and Judge Gregory simply said, we have jurisdiction, we're entering a plea on your behalf, and we're issuing a $10,000 bail. And I was like, wow, we just passed over all of the basics of what a court is supposed to do. I understand that I can be annoying to some people, but that's not justification for violating our statutes. And the city proceeded on from there, and they haven't let up. To be quite frank, Your Honor, it appears that the city's in an untenable position because I'm that rare squeaky wheel who just won't shut up. And, I'm not going to shut up as long as they're imprisoning my son from me. And they can't admit that they have policies and widespread customs that are literally violating the law. And, if they don't like the fact that they're violating the law, they should go to the legislature and they should ask the legislature to change the laws for them. I'm just citing the law. I didn't make them break it. So thank you.
Thank you very much.
Again, Your Honor, we're here on a very narrow question of whether or not a writ of prohibition should issue. There are two elements to a writ of prohibition. The failure of either one of those elements is dispositive that a motion for a writ must be denied. As the first question, whether the municipal court has jurisdiction or has acted in excess or in the absence of jurisdiction in the criminal prosecution of Mr. Benchu for violation of a no contact order, it is clear under state law that the city of Seattle has the authority to pass a criminal ordinance regulating disorderly behavior to include violation of no contact orders. and it is clear under the state law that the Seattle Municipal Court has original jurisdiction over all criminal cases arising from violation of the city's criminal ordinances. It is also clear under the Uniform Child Custody Jurisdiction and Enforcement Act that the Superior Court, Family Court had jurisdiction over the case of whether or who was going to get custody of Mr. Benchuf's minor child, and acted within its jurisdiction when it issued the original no contact order that is the subject of this particular criminal prosecution. As to the matter of personal jurisdiction, again, the Seattle Municipal Court served Mr. Benchuf in accordance with the criminal rules of courts of limited jurisdiction, 2.2 D2, which allows for a summons and complaint to be mailed to the defendant at his or her last known address, satisfying that personal jurisdiction was attached here in this particular municipal case. And again, each of these mailings are on the docket or docketed in these cases. As to the issue of whether or not there is a adequate, plain, and speedy remedy, again, Mr. Benchuf may have to subject himself to the jurisdiction of the court. He has to go down there. He may be subject to arrest, there may be some hardship, but he has adequate remedies within the municipal court to defend his case, to appeal his case if and when there is an outcome that he is or is not dissatisfied with, and to seek collateral, injunctive, or declaratory relief either in the family court, in the superior court, or to pursue a current motion that is, the current federal litigation that is ongoing. Having not met either one of the two elements for a writ of prohibition, I believe the prohibition writ should be denied.
All right, thank you. Mr. Benchuk, do you have any response?
Yeah, and thank you. This applies to both this case and the 671384. It was touched upon in our motions, our pleadings, but I think it's important to drive home the point that under 7.105.050 subsection 1A and B, Seattle Municipal Court, as a court of limited jurisdiction, cannot assert jurisdiction to prosecute me because Superior Court, King County, already they had already exercised, they asserted it, even though I think it was invalid. They can't have it both ways. King County Family Superior Court already asserted jurisdiction over my son. According to the statute, not even King County District Court could prosecute me. And Mr. LePierre's argument was that, well, the statute doesn't explicitly forbid Seattle Municipal Court from asserting jurisdiction, even though it's even a lower court than the district court. But, you know, Scalia's canons.
Okay. Sorry about the weird camera thing that I chose. I just turned it up on my phone. Just make sure it doesn't come through. And it sounds super choppy. So now I need to know if I sound choppy or not, because it doesn't sound like that for me in my ears. I'm fine. Okay, let's do this. Stop screen. Just going to go back a couple of seconds. Present. Share screen.
Exercised. They asserted it, even though I think it was invalid. They can't have it both ways. King County Family Superior Court already asserted jurisdiction over my son. According to the statute, not even King County District Court could prosecute me. And Mr. LePierre's argument was that, well, the statute doesn't explicitly forbid Seattle Municipal Court from asserting jurisdiction, even though it's even a lower court than the district court. But, you know, Scalia's...
Okay. Let's think about this. Here's what I'm going to do. They sizzle and crackle. So weird. Let me put this piece of pizza down first. The thing is, Lilith, for me, this one is perfect. What I'm going to do is Here's what I'm gonna do. Look at Winchester's face. I'm gonna try it from this computer. Um, okay.
Canons of construction. Expressio unius est, or expressio unius est exclusio, you know what I'm trying to say. The exclusion of one, can you help me? Just nod your head that you know what I'm trying to say. Essentially, that just because this statute doesn't forbid Seattle Municipal Court from exercising jurisdiction, that's not how our statutes are constructed. They typically expressly delegate the authority that a court has, and if it isn't expressly stated, we assume that the court doesn't, because otherwise our statutes would be 100 pages long if we listed everything they can't do. So that's, I think, a disingenuous argument, as much as I like Mr. Lapierre as a person. And the continued assertion that I have remedy if I will just subject myself to $350,000 in warrants, like, well, then they'll hear me. I have to say I object to the absurdity of that. Thank you, Your Honor.
All right, thank you.
You
Now
know, if
let's
I may have
move
one
on
moment.
to, pardon me?
If I may have one moment, Your Honor. I
Sure.
think that we need to be very clear here that Mr. Benchew's prosecution in case number 669329 is not under the RCW. He is being prosecuted under the Criminal Code 12A.090.020, to which the statute he's referring to doesn't apply.
Under an SMC statute or
Correct.
ordinance, I guess.
Yes, Your Honor.
Okay. Let's move on to the case ending in 764-1. This is relating to Seattle Municipal Case number 656
749.
749. You're ahead of me, Mr.
So,
all right.
Your Honor, plaintiff is requesting that this court issue a writ of prohibition prohibiting the city of Seattle organized crime syndicate from maliciously prosecuting me. I should say, I'm asking the court to issue a writ to prohibit them from sentencing me in this case, or seek arresting me, detaining me, or imprisoning me under the associated bench warrant, which I believe is $20,000.
Okay.
And something I haven't addressed yet, but which really applies to all of these cases, is for anyone who has any familiarity with the cases that have been heard the last several years in Seattle Municipal Court, these bail amounts they're literally insane, because I've sat in hearings where there were actual people who had committed domestic violence. They had choked their girlfriend into unconsciousness. The police showed up and there was bruises cases that they documented. I've watched Judge Gregory ask prosecutor Sahila Serafan why the bail was so high, and she was asking for $5,000 bail. Now, mind you, never in Miss Owens' ridiculous claims anywhere, she's never even asserted that I've ever spanked my child, that I've ever hit her, that I've ever threatened to hit anyone. She merely asserted that I'm a big, scary man that she wants to remove from my son's life so that her and her prostitute girlfriend can go live their white picket friend's life and pretend that I don't exist. So I'm not a DV perpetrator. I'm a pacifist. You know, it's so ridiculous. But as far as this case goes, again, the city did not have jurisdiction over a civil matter between the city and I, or between PCC employees and I. And I detailed in there how, you know, the city of Seattle and PCC, you know, I would bet money, I would bet the few dollars I have left that there's some relationships between the city and between the owners of PCC, because it's been a very cozy, back-scratching relationship. And they asked me not to leave money by the cash register because they were asserting that I was a health threat, even though I haven't been sick in the last 7 years. And then when I left it away from the cash register, away from their security cameras, then they said, oh, look, our security cameras show that you didn't leave money at the cash register. I'm like, can you get, there's no more ridiculous setup, you know, than that. And then Judge Lynch, who's presided over numerous
to issue question whether or not a writ of prohibition should issue in this case. Again, that is a very narrow inquiry. The first question is whether or not the court is acting in excess or in the absence of jurisdiction. And again, state law is clear that the city has the authority to issue criminal ordinances covering disorderly behavior, including trespassing and civil theft. It is clear that the Seattle Municipal Court has original jurisdiction over criminal violations of all of its criminal ordinances. Again, PCC, as a private property owner, has the ability to revoke any permission from anybody to enter into their property, and being in the property without permission is unlawful and is a violation of the criminal statute that was issued by the city of Seattle. As such, the court is not acting in excess of its subject matter jurisdiction. And getting to the issue of personal jurisdiction, the court is not acting in excess of that jurisdiction because Mr. Benchuk was again served criminal process. They summoned a complaint within the criminal case by mail in accordance with the criminal rules of courts of limited jurisdiction 2.2D that allows such service. There's a concern that the court is acting in excess of its jurisdiction in issuing a bail warrant in the amount of $20,000 in this particular case for Mr. Benchuk's appearance at his sentencing. While it is true that there may be other cases where, you know, allegedly more egregious crimes are accused against the defendants and that they have received a lesser bail amount, the severity of the alleged crime is only one of the small elements within the court's jurisdiction in determining the level of a bail warrant to issue to ensure the appearance of a defendant at trial. The first issue being how much bail on the warrant is necessary to ensure the appearance of the defendant. And Mr. Benchuk has a history within this case and within several other cases in front of the Seattle Municipal Court of failure to appear. That is before the court. And in this case, failure to appear at sentencing has resulted in the issuing of the warrant at issue. And such, the court is acting well within their jurisdiction to issue the warrant in question. As to whether or not there is an adequate remedy for any alleged wrongdoing in Mr. Benchuk's case, again, allegations of wrongful decisions or you know, abuse of discretion in decisions on evidentiary issues before the court are classic things that are subject to appeal after the case is over. And Mr. Benchuk, once the case is sentenced, is fully, you know, able to appeal the decision of the Seattle Municipal Court in any decision they made within this prosecution, including the decision of the jury to convict. There's also, again, as I say earlier, resource to the Superior Court for any injunctive declaratory relief, as well as the federal case that's currently ongoing, or any of the federal charges that, federal actions that may arise to enjoin or get declaratory relief about any errors that may have occurred within Mr. Benchuk's criminal prosecution. Having both elements of a writ of prohibition not being met, again, Your Honor, I believe the writ should be denied.
Thank you. Mr. Benchuk, do you have any, do you have a quick response? You don't have to, but if you wish.
Yes, thank you, Your Honor. First, because my character has been impugned,
I'd like to, for the record, state that I showed up to every hearing from September 2020 through June of last year. Even though I could see it was a kangaroo court, I came to everything. And at the point that they issued a $250,000 arrest warrant, when I had done nothing wrong but try to love my kid, that's at the point where I had to choose between ever getting out from jail again, because all of the evidence, I mean, that's a long time to gather evidence. Every indication was that certain city officials, they want me locked away and shut up for as long as possible. So I had no way to affect my release. At that point, I had to choose. I'm like, I need to be out here where I can litigate to get my son back. You know, and this isn't just an abuse of discretion, an Eighth Amendment violation of excessive bail. Like, I understand people want to say judges have absolute immunity. They do, unless they're acting in the absence of jurisdiction. And I've shown that the city has a policy, they've admitted it, of violating personal jurisdiction. And, you know, and again, under RCW 7, oh, sorry, we're on the trespass one. I've argued and shown the city can pass its codes, but it can't apply codes to me that I'm not violating. I was never trespassing. Like, I'm sorry, you know, is a violation of the equal protection law the entire time. And again, Mr. LePierre's assertion that CLJ 2.2D magically authorizes the city to violate RCW 7 or RCW 35.20.270, that's absurd. The city does not get to put its rules above state law. And I think it's, I mean, come on. We all know that that's not how laws work. So, and, you know, again, as far as, oh, I should have tried this other motion in this court, like, I've been all over the place. I tried an injunction in the Fed. You know, I can't even appeal this case because it hasn't gone to sentencing. And I can't go to sentencing unless I'm willing to be indefinitely, you know, stuck in Gitmo. So thank you, Your Honor.
All right, well, thank you very much. I think that concludes all four of them. Let me tell you this, what I'm going to do is, there's a lot here for me to digest. I think the law, as you set out, Mr. Benshoff, is detailed and intricate, and the facts are in part complex. So I am going to take it under advisement, give myself a little bit more time to noodle through these issues and facts. My goal is to get something out as soon as I possibly can, which I know is a very judge vague term, but I am going to do my best to get it out, because I think it's in the interest of both parties to have some closure, or at least what is being asked of me closure-wise. So I'm going to do my best to get it out as soon as I can, but I'm going to take it under advisement. All right. Thank you.
Honor, I just wanted to say, take as long as you need to do your work. I understand that you guys have a big caseload, and I just wanted to thank both the court and Mr. LePierre for giving me an opportunity to speak today.
Of course, thank you. And I have to give you compliments on the pleadings that you drafted. Well drafted. All right, everybody, have a nice weekend.
Okay, thank you.
Have a nice weekend.
Thank you.
Bye-bye.
Be a reset. Disconnecting the
The facts and quoting the law. What
your video. Thank you so much.
All right, ready, Madam Bill.
All right, thank you. Good afternoon, court is in session. Your Honor, this is Kurt Benson versus Nathan Fiber et al. Cause number 222-159-588 SCA. Plaintiff representing yourself, excuse me, representing yourself, will you please introduce yourself to the court?
Yeah, this is Kurt Benchoof, plaintiff pro se.
Thank you. Counsel, if I leave anyone out, please correct me. Counsel for Nathan Kleiber.
Good afternoon, Mike Tracy for Nathan Kleiber, and Sarah Turner, my co-counsel, is also here.
Thank you. Counsel for Defendant Counsel for Jessica Owen.
And good afternoon. For the record, Blair Russ appearing on behalf of Ms. Owen. I also have Ms. Gagliardi in my office online as well.
Thank you. Counsel for Magali Lerman.
Good afternoon, Moshe Admin on behalf of Magali Lerman and Owen Hermson.
Thank you. And if we have not missed anyone, Your Honor, we are ready.
All right. Thank you, Madam Bailiff. Unfortunately, we are here because it appears to the court that Mr. Benchoof may be in violation of the court's order entered back on March 31st, 2023, restricting abusive litigation filed by Mr. Benchoof. We're here on Mr. Kleiber's motion for a finding of contempt and for sanctions. I have reviewed that motion. I've reviewed all of the materials submitted in support of that motion. I've reviewed Mr. Benchoof's response and his cross motion and all of his materials, as well as the reply materials. I want to state at the outset that there may be other pending motions that have been filed in this case, but in particular by Mr. Benchoof. We are not here to have a free-for-all on all pending motions. We are only here addressing the contempt and sanctions motion. I had a few questions for the moving party, and then I wanted Mr. Benchoof to give Mr. Benchoof an opportunity to address his opposition, which I've read and I'm familiar with his positions. And I will say at the outset, I am highly skeptical of Mr. Benchoof's positions. I want to say that the order I entered back in March of 2023, in my view anyway, was unequivocally clear and broad, that it applied to any and all future litigation by Mr. Benchoof against the protected parties. And there's similar language throughout the order. And the court laid out strict requirements that Mr. Benchoof had to follow before bringing any new actions against the protected parties, not just lawsuits, but actions. I will further add that at least in one instance, Mr. Benchoof filed what he framed as an answer and counterclaims in federal court, but what was clearly a third-party complaint directed at the protected parties in my order. Mr. Benchoof might have thought he was being clever, but he's not. I can tell him that he is not the first person to try that trick to avoid the mandatory requirements of Federal Rule 14, which require service of a summons and complaint. When you do things like that, you can't just call it a counterclaim when really what you're doing is commencing a third-party complaint.
Objection.
Mr. Benchoof, I absolutely will give you an opportunity to respond. I just want to kind of cut to the chase here about how I have viewed the materials that were submitted to the court. I know you have an opposition. You oppose all of these positions, and I want to give you an opportunity to respond, and you'll have that opportunity, I promise you. But first, I'd like to hear from the moving party or parties on the motion, starting with Mr. Tracy and Ms. Turner. I don't know who's going to argue between the two of you.
I'll be arguing today, Your Honor. Thank you. In our view, this is really pretty straightforward. The order is very clear. It simply amounts to a series of yes or no questions. And the first question is, when filing a new action in federal court, which is what our motion concerns, I know that some of the other parties deal with a few other actions that extend beyond that, but for ours in particular, there's two actions in federal court. The first was filed directly by Mr. Benchoof against a litany of defendants. When he filed that, he failed to file the leave motion, which is the first requirement of the court's order. And then the second part of that is filing a copy of the order. Now, in that case, he did file a copy. We still do not feel that really meets the spirit of the court's order. It was included as one of, frankly, dozens of documents that were filed in a single appendix. It was about 2,000 pages long, kind of included in the stack, as opposed to acknowledging the order directly or its requirements.
Right, it was buried.
Yeah,
is my impression. It was buried.
Thank you, Your Honor. We agree. For the second action, this is a declaratory judgment action that was filed by Seattle School District regarding some records concerning Mr. Benshoof's child. And as the court noted, he responded, brought a variety of third-party claims against many of the protected individuals here. And in that action, he also failed to file the leave motion and likewise did not file a copy of the court's order. As a fair bit of time has passed since we initially filed our motion, I just wanted to clarify for the court that in both of those actions, because Mr. Kleiber was served with copies of the complaint and summons, we have responded filing motions to dismiss, calling attention to the order and some of the actions that it empowers other courts to take as well. But at this point, it really just comes down to whether he filed the leave motion or not. He didn't in either case, and those cases continue on and have caused quite a substantial cost, both of the individual defendants and of those courts and this court's resources, given Mr. Benshoof's failure to comply with the order. Now, in our materials, Your Honor, we left it pretty open as far as what sanctions or fines of contempt or jail time, anything of that nature, the court would enter. Since we filed ours, counsel for Ms. Owen has filed their own sanctions motion, and their motion, they went into a little bit more detail. We would just state that we do not oppose any of the specific sanctions sought by Ms. Owens, including the remedial sanctions under RCW 721, 010, and 030, which could include daily sanctions until Mr. Benshoof complies with the order, as well as a short amount of jail time.
I will say jail time is typically utilized to get to coerce compliance, and I appreciate an explanation for how jail time would serve that end, and not be simply just kind of punitive. But thank you, Mr. Tracy. All right, Mr. Russ.
And thank you, Your Honor. For the record, once again, Blair Russ, appearing on behalf of Ms. Owen. We did file our motion that was substantially similar to Mr. Kleiber's motion, unsurprisingly, because the facts are relatively similar and there's a lot of overlap there. I think we spent a little bit more time talking about the available options the court might have in addressing Mr. Benshoof's ongoing vexatious litigant behavior. I think what's also important for us to point out that is unique to our motion is that, as this court's well aware, there's already been a no contact order that's been issued in a custody matter, which requires Mr. Benshoof to refrain from contacting Ms. Owen. We've supplied a declaration with close to 240 communications over a short period of time. It's just another continuation. In fact, I would say it's an escalation of this abusive behavior that another judge has told him he cannot engage with under threat of criminal penalties. That has not deterred Mr. Benshoof, of course. He, as the court also knows from hopefully other filings that we've submitted, he's already out. I think he's got a $250,000 warrant. I think the count is maybe 91 criminal charges that stem from violating Judge Keenan's order. I don't think the court necessarily is in a position to enforce an order of another judge, but I think the importance of that circumstance is Mr. Benshoof's willingness and propensity to violate court orders continuously. And appreciate the court's comment that there are two sort of variations of sanctions in the circumstance. There's a remedial sanction, which is designed to cajole or compel compliance. There's also a punitive sanction. I think probably we are not in the appropriate procedural posture for a punitive sanction. We are, however, in the appropriate procedural posture for a remedial sanction. And the reason being is that Mr. Benshouf can curtail his violation of the court order by simply calling the vexatious litigant order to the attention of the judge presiding over his federal court matters. My understanding is they've both been consolidated in front of Judge Whitehead, and he can ask Judge Whitehead for leave to proceed prior to taking any additional actions, if any, against the defendants. If he's unable to achieve that, he can also dismiss that claim as a matter of right. And so he is in a position where he can meet the court's order, or at least curb his violation of it. A remedial sanction would be appropriate in that circumstances. We have suggested $1,000 per day per defendant per action, per protected party. So that would include Mr. Admon, Ms. Owen, Ms. Magali, myself, Mr. Kleiber. I think that, I'm sure there's others, but at least there's those five off the top of my head, plus two other two actions combined. So it would equate to something like a $10,000 sanction per day before he could achieve compliance. And I believe he can go ahead and dismiss this as a matter of right under CR 41. So it shouldn't take him more than a day or two to be able to do that. He's definitely familiar with the process for filing in federal court. So if there's anything else that I can add or give the court, happy to do so.
Was jail time one of the proposals, Mr. Russ?
It was, right. It was loosely suggested in sort of the spectrum of available remedies the court would have. I think the importance of jail time is that in issuing your order, you supplied the night warnings with it, so that Mr. Benshouf was on notice that jail time was a prospect. That has still not deterred him. And jail time is a inappropriate remedial sanction, as the court knows. It's allowable under the statute. You don't have to bring criminal charges like you might with a punitive sanction. It is permitted, and folks that are in jail do still have access to the federal court. So I do believe that, given the propensity to willfully violate orders, putting Mr. Benshouf in custody until he complies, it would in fact be an appropriate exercise of the court's discretion.
Thank you, Mr. Russ. Mr. Admin?
I have nothing to add, Your Honor.
All right. Well, Mr. Benshouf, you've heard what I've had to say. You've heard what the other parties have had to say. Like I said, I've read your materials. What further information do you have, or argument do you have for the court?
Well, first of all, I'd like to say good day. I didn't have the pleasure of being on the video feed on the hearing back in January of 2023. And I would also like to thank you for being forthright about your prejudice before the parties have even had a chance to speak. As you've said, you've read through my briefings, and this laughable kangaroo court action that's been going on for more than a year, where counsel were allowed to assert that I had engaged in abusive litigation. I'll read for the record, RCW 26.51.020 subsection 1A subsection 2 says that the party who is filing, and in that case it was initially Miss Owen and there was a joinder, has that I, as the alleged vexatious litigant, has been found by a court to have committed domestic violence. That's what the statute says. My understanding is that lawyers in courts are required to follow the law. No one has ever presented evidence that a court found me to have committed domestic violence. So the definition of domestic violence, or sorry, the definition of abusive litigation was falsely applied from the get-go. And then under RCW 26.51.030, the orders restricting such alleged abusive litigation, which doesn't apply to me, subsection 1 states that I would have, quote, been found by the court to have committed domestic violence against the other party, in this case, Owen. That has
Are you
never
talking about my order, Mr. Benchoof? Is that, you're talking about the abusive litigant order that I entered in March of 2023? You're saying that order doesn't apply to you?
No, what I'm saying is that for the attorneys to have even petitioned for an abusive, for an order restricting abusive litigation, a court had to have found that I committed domestic violence against Ms. Owen. If you actually read the record of King County Superior Court case number 21-5-00680-6 SEA, I was never found to have committed domestic violence. What Mr. Kleiber, who is a pathological liar like his client, Ms. Owen, the little game that he played with Judge Keenan was alleging that I was a credible threat. And that allegation was upon one of my unlawful arrests, which was dismissed with prejudice. Now, the term—
So, Mr. Benchoof, I will say that what you're doing now, the arguments you're making now, you can save for the Court of Appeals, because what you're doing now is saying that I was wrong to enter the order restricting your litigation. You can believe that, that's fine, but I've entered the order and we're not relitigating that. If you think I was wrong, you can take it up to the Court of Appeals and maybe you'd win there. I think you have appealed, but I'm not going to reverse my order at the end of this hearing. There's no chance of that. And so there's no point in trying to relitigate the order that I entered. The question here is whether you violated it.
Yeah, and Your Honor, I am well aware that I have appealed the order of the court in the Washington State Court of Appeals Division 1. So we're all aware of that. Okay. And I am not here to move for the vacation of that order, as fraudulent as it was. That's not the issue. The reason that I am, for the record, setting these facts is because I will be getting a transcript, and based upon the prejudicial statements I've heard so far, whatever determination comes out of the court today will also be appealed to the Court of Appeals. And the reason I'm raising these issues is not to relitigate what the court and the councils present did previously. It's to establish that when the court issues its prejudicial ruling today, either sanctioning me or issuing an arrest warrant or whatever games we want to play, that it is on the record that the basis of this is known by all parties present, attorneys and the court, to be based on fraud. It's fraud upon perjury. And we all know that under Throckmorton, that perjury and extrinsic fraud voids everything. So while counsel and the court wish to continue with this ridiculous tautology that I am disrespecting orders and violating them, I will quote from a U.S. Supreme Court case. Quote, "An unconstitutional act is not a law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed." That's Norton v. Shelby County, 118.
Right. So, Mr. Benchoof,
1886.
until you get an order from the Court of Appeals saying that my order was unconstitutional, it is a valid order and you are required to follow it.
Well, I understand that that's the court's position. And my position is that when we all know it was obtained by fraud, it is yet another injustice. Like, this is the same game that's been going on for over 2.5 years. Judge Keenan allowed, enabled, and facilitated Nathan Kleiber to suborn the perjury of Jessica Owen. That is irrefutable, and counsel won't even touch it with a 10-foot pole because they know it's a fact. Okay.
If it's irrefutable,
This is my time, isn't it, Your Honor? Why are you interrupting me?
I want to make.
You asked me not to interrupt you.
Right.
I'm going to
I'm
ask
interrupting
you not to
you
interrupt me. Thank you very much.
Because, well, I can't, because at 2:00, this hearing is going to end. And I want to make sure that you address directly the court's concerns about whether you have violated this order. If you spend a lot of time arguing about the past and your belief that the order is fraudulent, you can waste your time and do that. I'm not going to reverse this order or vacate it. So I'm hoping you will directly address the motion at hand. And I want to go back to the beginning, actually. The reason why you think my comments were so prejudicial. I already decided that I'm going to grant the motion. I didn't need to hold this hearing. This hearing is at my discretion. I had questions from the moving party about the kind of sanctions they wanted the court to enter. I do not need to hear oral argument from you to grant this motion. Motion was filed without a request for oral argument, and I was prepared to grant it without any oral argument. I am permitting you to address the court in case there's more information that you think I should know about before I formally grant the motion, and which is why I'm asking you to directly address the motion and whether you violated the court's order, rather than spending your allotted time arguing about the lead up to the entry of my order and why you believe it's fraudulent and unconstitutional. Again, you're welcome to do that. But if you have information that more directly answers my question as to whether you violated the court's order, I'd like to hear that.
Okay, Your Honor, how many minutes do I have to speak?
Well, it's 1:23. And I need to get back to the other matter at 2:00. I'd say you have about 20 minutes.
Okay, thank you for clarifying that, Your Honor. It's my understanding as a pro se litigant that once the court decides to convene a hearing, which the court did, that I have a right to speak. So how I choose to spend that time and what statements and evidence and law I think is relevant is my choice, and I would hope that all parties in the court respects that.
So there are limits, but you may use your time how you wish, Mr. Benchoof.
Thank you, Your Honor. I will also point out that I gave the court the benefit of the doubt that it had been fooled by counsels back in January of 2023. That despite the fact that Your Honor had just spent, I believe, a 2-year rotation in family court before this case commenced, which is why there was a delay, that despite that, I gave the court the benefit of the doubt that maybe the court just wasn't aware of what the laws actually state. And because
just to correct you, Mr. Benchoof,
please, thank you.
It was 2 years in dependency, and I spent 20 years in civil litigation practice.
Thank you, Your Honor.
All right.
So I gave the court the benefit of the doubt because, as I've stated in my pleadings, I wasn't aware that opposing counsel were moving under RCW 26.51 until months after the hearing when I was able to obtain the transcript. And for the record, in that hearing, upon further review, it was actually the court that brought up the Kuhlmeyer case, if I'm pronouncing that correctly, and moving for an order restricting abusive litigation under RCW 26.51. So at present date, plaintiff finds it hard to believe that the court and all opposing counsel were not fully aware prior to the order being issued that this order was fraudulent. It was void ab initio. And I've done my best to give everybody the benefit of the doubt, everybody an opportunity to correct their errors. And I'm well aware that that there's an appeal process for this. But my position is that any further attempts to enforce this order constitute further fraud and constitute in attempts to silence me in violation of the First Amendment by denying my right to redress under threats and coercions. Mr. Russ knows that Miss Owen is a perjurer. Mr. Tracy and Miss Turner know that Mr. Kleiber suborned the perjury of Miss Owen. They've been served lots of documents. And so this whole clown show that I'm supposedly the bad guy because I'm trying to protect my son from ongoing abuse, and that I'm annoying and somehow causing people problems because I keep speaking the truth and trying to stop the ongoing abuse of my son and the ongoing violations of state and federal law. It's hard not to laugh when I hear attorneys and judges continue this charade, because that's all that it is. So to get back to the controlling law, so that this is all on the record for the Court of Appeals, that's my purpose. It's not to change anybody's opinions, because it's obvious to plaintiff at this point that attorneys and the court have already determined that they don't care about the law, they don't care about the facts, they don't care about my son, and the last thing they're gonna let happen is the fraud be admitted on the record. So while parties in the court may not wish to admit it, I am going to further establish it for the transcript for the Court of Appeals. And yeah, so as I've said before, the family court, even if it had determined that I had committed domestic violence, which it never did, and if you read the record, it shows that Miss Owen actually committed domestic violence. I never did. But the court, Mr. Keenan, Judge Keenan looked the other way on that, just like he looked the other way on Mr. Kleiber suborning Miss Owen's perjury, just like Mr. Keenan, Judge Keenan looked the other way about the fact that Kleiber brought a Beatrice petition to decide parentage, which was just a ruse, because as Mr. Turner and Miss Tracy are well aware, Mr. Kleiber is a family law attorney. He knows what RCW 2626A 43A subsection 435 subsection 2 says. It showed that the court was collaterally estopped and really should have invoked judicial estoppel as soon as Mr. Kleiber brought the parentage action, because Miss Owen's sworn statements, some of which Mr. Kleiber signed his name, he undersigned his name, which means, yes, there is proof he suborned her perjury. Miss Owen and Mr. Kleiber were collaterally stopped from Miss Owen making materially mutually exclusive material statements of fact between case numbers 21-2-11149-8 and 21-5-00680-6. That's exactly what she did. But even more hilarious, those statements, they were extrinsic and collateral fraud, because what they did was she took mutually exclusive positions, first saying that I had acted as my son's father for all 12 years and that he was my child, because he is, and that we'd lived together. And then she had to take the opposite position to make her parentage petition to decide parentage seem plausible by saying that, oh, no, we'd never lived together. He's not the presumed parent. I don't know who the father is, and he has no parental rights. It's a clown show. So I hope that some of you find it as funny as I do. So as I was saying, even if Judge Keenan had falsely claimed that I committed domestic violence, which he did not, neither did Holloway, neither did any of the other judges or commissioners. Okay, so no court has ever determined me to have committed domestic violence. That's irrefutable. And counsel here have yet to provide that proof, because they can't, and they know it. And if I were them, I would be embarrassed at this point. But anyways, so even if I had committed domestic violence, family court, Judge Keenan never had jurisdiction. I'm not saying that because I'm opposed to the power of courts. I'm saying it because any first-year law student knows that a court only has jurisdiction, the authority to speak, if it has facts and matters in controversy before it, which it is duly authorized to adjudicate. And as SB 626A 435 subsection 2 states, and I will read it out for you. A presumption of parentage cannot be overcome after the child attains 4 years of age. Judge Keenan did not have statutory authority to hear anything or do anything. And the restraining orders that Judge Keenan issued, including the final order, are also void ab initio. Why? Well, let's look at RCW 26.09.050. Sorry, 2609.050. And you'll find the same thing in 0.060. The court had authority to issue a restraining order under that statute in entering a decree of dissolution of marriage or domestic partnership, legal separation, or declaration of invalidity. It was doing none of those because, as I've said for 2 years, the court never had evidence of domestic relations. It had no—
10 minutes remaining.
Thank you, Your Honor. I'm having fun. I hope you are too. The court never had authority to issue any parenting plans, as under RCW 26.09.004, subsections 3 and 4, permanent parenting plans and temporary parenting plans, just like the restraining orders under 26.09.050, subsection 1. Those are plans incorporated in any final decree or modification of, what's the magic words? Dissolution of marriage, we were never married. Or domestic partnership, we were never in a domestic partnership. Or a declaration of invalidity, or a legal separation. So it's unfortunate. I understand that the court and counsel are maybe in an uncomfortable position, because what annoying Mr. Benshoof has done, and I say annoying tongue in cheek because all I have been doing for 2.5 years is saying the facts and quoting the law. What has been shown is that King County Superior Court has been routinely violating the law, violating people's rights. I'm sure I'm not the only one. And we come to the final restraining order granted by Judge Keenan on October 21st of 2022, based upon the perjury by Jessica Owen, the suborning of her perjury by Nathan Kleiber, and Judge Keenan allowing, enabling, and facilitating it. And that restraining order says it ends in 1 year or it ends on September 28th, 2027. Well, you don't get to issue restraining orders for 5 years. That's not how the law works. And it says duration under RCW 7.105, it says that they shall not be issued for longer than 1 year. Now, under RCW 7.105, 0.315, subsection 2A, it says, quote, if a protection order restrains the respondent from contacting the respondent's children, the restraint must be for a fixed period not to exceed 1 year. Then it goes on to say this limitation is not applicable to protection orders issued under RCW under chapter 26.09. I've already documented why the Keenan court never had authority to issue anything, parenting plan, restraining orders, anything under 26.09. So this savings clause that shysters might want to cite as reasons why Kleiber and Keenan and Owen could issue a restraining order that ends in 2027, that doesn't work. So coming back around to the court wishing to issue, some sort of penalties or sanctions for plaintiff continuing to cite the law, state the facts, try to bring criminals to justice, stop the ongoing fraud, and stop the ongoing abuse of my son. Well, let me come back to Mr. Russ bringing up Judge Willie Gregory's restraining order that he issued, I believe it was on November 16th of 2022 in Seattle Municipal Court case number 669329. Now, I was there, nobody else was there, so to consider. And at that hearing, before the hearing, I filed a motion to dismiss because I had irrefutable evidence, which Seattle Municipal Court City Prosecutor Katrina Outland has not and cannot refuted, that the court was proceeding without personal jurisdiction as well as subject matter jurisdiction. Why do I say that? Because RCW 35.20.270 subsection 1 clearly states that a municipality is required to issue criminal summons by personal service. They don't do that. And Miss Outland later in federal court, or no, sorry, in the in one of my writs of prohibition, King County Superior Court case number 23-2-23749-8. In that, she submitted a declaration which admits that the city has a policy, custom, practice, and procedure that they violate RCW 35.20.270 subsection 1. That's just how they do it. And because they're the city, they get away with it. And while I very much enjoyed the hour before Judge Larrañaga, I think he was in a tough position as a new judge, because it would probably be professional suicide for him to be the one judge that finally acknowledges the facts in the law, which is that the city of Seattle is an ongoing RICO crime syndicate, which is another reason why people find me annoying, because I have the evidence of that. So when Mr. Russ, amongst his many prevarications, claimed that I had violated the quote unquote restraining order out of Seattle Municipal Court issued by Judge Gregory did not have jurisdiction to issue that. I told him on the record. And it's coincidental that today in Washington, Western Washington, case number 2:23-CV-1392-J&W, today I filed affidavit of service against Judge Willie Gregory in his individual capacity. I filed a motion for entry of default because Judge Gregory, or sorry, Willie Gregory in his individual capacity, he just hasn't refuted any of his claims. Now, why do you think Willie Gregory hasn't refuted any of his claims? Why do you think he ignored the summons? I wonder if anybody here is concerned that city prosecutors, city judges, oh, did I mention that King County also failed to answer the summons in that lawsuit? Do you think it could possibly be that all of these individuals are faced with a difficult choice? They either ignore the summons and go in default, which is happening on a daily basis, as happened to City of Seattle as well. They're faced with the tension because I've pled RICO allegations.
3 minutes.
So they're between a rock and a hard spot, Your Honor, because if they answer the complaint and if they don't get their motion to dismiss granted, which good luck with that, then they're faced with videotape depositions under oath, and they're faced with the prospect of taking the stand in a public trial. So it should come as no surprise that all of these corrupt public officials and corrupt attorneys and pathological liars like Miss Owen, Miss Lerman, and Mr. Hermson, which I will remind the court, their sworn affidavits last year that they submitted. I submitted an affidavit in response, pointing out point by point all of the perjury that they committed. But of course, the court doesn't care about perjurers, because as long as you're lying about the squeaky wheel, Mr. Benschoof, you can commit any crime you want. You can say any lie you want with impunity, because that's the clown show world we live in. So, you know, you may wish to get a hold of Dow Constantine and ask him why the King County, why I motioned for entry of default. Why didn't they answer the complaint? Why are all of these parties refusing to answer summons? So I find it hilarious when counsel and judges accuse me of not respecting the law, not respecting orders. No, I'm laughing, guys. So I'm going to make this suggestion. If you guys all want to continue with this kangaroo court charade that I've ever lied about anything, that I've ever violated any law, that I've ever violated any valid order, then I suggest that you move for the death penalty. Oh, wait, sorry, we rescinded that. Probably because there's so many pedophiles in the state in positions of power, they really don't want that. So how about this? Why don't you issue an order for 10 years of imprisonment, and let's make it $1 million per day fine until I shut up. That's my suggestion. Thank you, Your Honor.
Well, I don't know what I just heard. But what I can say is that I heard 19 minutes of argument by Mr. Benchoof, none of which had anything to do with the court's order restricting abusive litigation. I mean, other than as background, and nothing directly addressing the motion for sanctions and the contentions that that order has been violated. Everything else I heard related to a galaxy of other legal actions and grievances that Mr. Benchoof has that remarkably have not led to any judge agreeing with him in state or federal court at any level that I'm aware of, although I could certainly be proven wrong.
That's called corruption, Your Honor.
I mean, it could be that every judge in the state of Washington and the federal court system is corrupted and prejudiced against you, Mr. Benchoof, but there are other possibilities that you might consider as well. Anything further, Mr. Tracy?
No, Your Honor. Thank you.
All right. The court grants the joint motions for contempt and for sanctions against Mr. Benchoof for violating the court's order restricting his abusive litigation. I do find that he's in violation, specifically in connection with his filing of the two actions in federal court, the one ending in 1392-J&W and the other ending in 01829-JHC. My order required that Mr. Benchoof accomplish a couple of things whenever he tried to bring a new action against the protected parties to my order. One was file a copy of my order with those actions. He did in one case, but he buried it in hundreds or thousands of pages of material so that it probably would not be seen by the federal court judge. But he didn't do so in connection with the other action. In neither action did he bring a motion for permission to file the action in federal court. And in that second action, although he characterized his claims as counterclaims, they were definitely not counterclaims. He was suing the protected parties under my order in federal court through a third-party action. It was within his power to comply with the court's order. It was within his power to separately file copies of my order in federal court. It was within his power to bring motions requesting leave to file those claims. And he didn't do it. And the court has not heard anything today from Mr. Benchoof explaining why. And so accordingly, the court orders the following sanctions against him. First, the moving parties shall be entitled to their attorney's fees in bringing these sanctions motions, including the reply briefing. The court will extend the expiration date of the original order restricting abusive litigation an additional year. The original term of the order, I believe, was 5 years. Let's see. I should have highlighted this. Where did I put the expiration date here? Oh, here it is on page 5 of my order. Yes, so it was originally 5 years from the date of entry of the order. So March 31st, 2028. The court will extend that 1 year to March 31st, 2029. And the reason for that is remedial. Mr. Benchouf has forced the protected parties to spend many months dealing with his new cases, his new abusive litigation in federal court. He's required the parties and their attorneys to file this motion to seek remedial sanctions. And it's clear to the court that he doesn't seem to have any intention at all of complying with this court's order, which he views as fraudulent, notwithstanding that the order has not been reversed by any court of appeals. What I wanted to ask about in terms of the sanctions is whether there is a basis for imposing a daily sanction where I think at least one of those actions has been dismissed. Is that right? I have both of them been dismissed? I guess is it moot at this point?
Thank you, Your Honor. Both are actually still ongoing. Both actions have pending motions to dismiss before Judge Whitehead.
Okay.
He's not ordered on either.
And Your Honor, if I may clarify, I believe those pending motions are just for Mr. Kleiber. So Ms. Owen hasn't been served. I haven't been served. So that, I guess.
Objection. Miss Owen was served and a motion for entry of default. So please don't lie, Mr. Russ, although it is your.
Right. Well, I guess Mr. Benchouf's entitled to his opinion, but that's my understanding. So that those cases are still pending as they relate to myself, Ms. Owen, Mr. Admon, Ms. Lerman.
All right. And I'm wondering what the practical effect would be if the court were to impose a daily fine requiring Mr. Benchouf to comply. In other words, requiring him to bring a motion for leave in the federal court. So I guess my question is, would that be creating more work for you and your clients? Would that potentially be creating more harm in having to litigate that motion for leave? I mean, the action's already underway.
Thanks, Judge Ferguson. So from Mr. Kleiber's perspective, the briefing on the first filed action, the 01392, the briefing is complete. So forcing Mr. Benchouf to file the leave motion, I don't think in our estimation would really add to our plate in that action. The briefing for the other action will conclude this week. And so I don't see that would cause us any additional delay or stress. So, and as Mr. Russ noted, only Mr. Kleiber has appeared and moved to dismiss. So all of the other affected individuals would still be part of those actions, even if we were successful on our motions.
Okay, and then requiring Mr. Benchouf to separately file a copy of of my order in those actions would that impact the litigation in any way? Have the parties already litigated over that order in any way?
So in both, Your Honor, so in the first action, we dug through the pile and found it and cited to it in our motion to dismiss. And in the second action, we actually filed a copy of it as part of our motion to dismiss. So it is in the record in both actions now. Though I will note that when we filed this present motion, we hadn't got to that stage in those other litigations. So they had not been filed at that point.
All right, then what I'm inclined to do is award additional attorney's fees for the effort it took for you to bring the court's abusive litigation order to the federal court's attention. In other words, at this point, I don't think we need to rely on Mr. Benchouf to bring that order to the court's attention. It's already been done. And I think if I were to enter a daily fine to get him to do that, a reviewing court might question whether that was really necessary, given that it's already been brought to the federal court's attention. But I think you and your clients are entitled to be compensated for the time it took for you to bring it to the federal court's attention. And so if you want to include your time in your fee petitions for attorney's fees for that work, the court would compensate the parties for that as a remedial sanction. I would like the contempt order to clarify for the benefit of Mr. Benschoof that going forward, the court's requirements regarding filing a leave motion and filing a copy of the court's order unequivocally applies to all claims, counterclaims, third-party actions, cross claims, any action of any nature whatsoever against the parties protected by the order. This is not a new term that I'm adding to the order. The order already contained very broad language covering every action of any kind whatsoever. But I would like this contempt order to clarify that this specifically covers counterclaims and third-party claims and cross claims and any other kind of claim. And while I'm not imposing jail time and I'm not convening a further hearing and I'm not appointing Mr. Benschoof a public defender, that we may be escalating toward that type of a sanction, whether as a remedial sanction or potentially down the road even as a punitive sanction. If things get that bad, jail time is a possibility, including the issuance of a bench warrant. But I'm not ordering that today. Would you, Mr. Tracy or Mr. Russ, prepare an order?
Yes, Your Honor.
I did review the order that Mr. Tracy that you submitted, laying out the findings of fact. That does comport with the court's oral ruling here, and so you could include that language as well.
Okay.
And Your Honor, just one issue for clarification I want to point out. So Ms. Owen, nor myself, nor Mr. Admon, nor Ms. Lerman have participated in the federal court action to this point. We do believe that your order had a very good procedural requirement in it, in that before proceeding against these persons covered by the order, there would be some sort of leave sought from the federal court. Given we haven't filed a motion, it's by not requiring Mr. Benschoof to comply with that aspect of the order, we still.
That's a fair point, actually. That's a fair point.
Oh, yeah, good point. Mm-hmm.
So, Mr. Russ, the court will amend its order specifically as to your client and Mr. Lerman. And I don't recall if Mr. Hermson was also a party. But as to any other parties who have not yet been served or have been, Benschoof intends to proceed with, to the extent that he intends to proceed with those actions, then the court will order that he comply with the court's order and bring a motion requesting leave to pursue those actions in the federal courts.
So I'm not clear on what is this. This is an additional stipulation for new actions, or the court is asserting the jurisdiction.
Sure.
To impose,
No. I'm happy to clarify, Mr. Benschoof. So I'm looking at the action, just for example, in the Western District of Washington under case number 223 CV 01829-JHC. That's the one where you've brought third-party claims and tried to disguise them as counterclaims against Mr.
Objection, I
Kleiber.
did not disguise anything. I did a joinder and a counterclaim. So
Against
I
Mr.
object
Kleiber,
to those.
Ms. Lerman, Jessica Owen, and Mr. Russ. In that case, I understand Mr. Russ to be arguing that his client and perhaps others have not yet been participating in that action, but it is still ongoing against them. And so for example, there's no motion to dismiss them out of the action, is my understanding.
That is correct, Your Honor, because
right. So, Mr. Benchoof, let me finish. I'm explaining to you my order. And because that is the case, and because you have not yet complied with my order to seek leave from the federal court to sue them, I'm going to impose a daily sanction against you. I'm going to give you some time to comply. I'm going to give you 1 week to comply with the court's order, and that's 1 calendar week. I'm going to, and then after that calendar week expires, the parties will be entitled to a daily sanction of $250 for each day that you don't comply with the court's order. And that's $250 per party. That's $250 for Mr. Russ. You're a party yourself, Mr. Russ, aren't you?
Apparently so. I haven't been served, but I've been named. I think I've been named 3 times by Mr. Benchoof.
So, Your Honor, are you saying that that despite the fact that, for example, Miss Owen was already served summons and complaint signed for by her prostitute perjure girlfriend, defendant Magali Lerman, that even though she served summons,
it's not a service issue, Mr. Benchoof. It's not even about, the question isn't service. You need the court's permission to pursue an action because I've entered that abusive litigation order against you. And so you need to comply with my order and bring a motion in federal court asking for that court's permission to proceed with the action against those parties. And you have a week to come into compliance. If you don't bring that motion in 1 week from today in compliance with the court's order, then the sanctions will accrue in the amount of $250 per party per day. Now, if between now and then you dismiss all the parties out of the lawsuit, then there will be no sanctions. If between now and then you comply with the court's order and bring that motion, there will be no daily sanction. But if you don't bring that order within a week, it's $250 per party per day.
And Your Honor, just one other point of clarification. So, and I recognize the procedural history is irregular here. There are a total of 2 pending federal court lawsuits where persons covered by the order are named who have not moved to dismiss. There was a previously filed lawsuit that was assigned to Judge Jones that was dismissed with prejudice. It's already gone up on appeal and it's been mandated. Right. So there are currently 2 actions pending. Is it the court's intention to require Mr. Benchoof to bring a motion to leave or dismiss in both actions that are still pending?
Yes.
And would it be excuse me.
And also any new cases, if he's got a new case in the hopper that I don't know about, then he shall bring a motion in that case as well.
So that's a good question, Your Honor. Thank you very much for bringing that to my attention. In the event, hypothetically, of course, that I were to file for a federal injunction to enjoin the court and all parties from continuing what plaintiff alleges to be ongoing fraud, are you suggesting that even if parties aren't named, but I'm only seeking to enjoin the court's enforcement of the order, should I also, is your position that the court is requiring me to file a motion for that as well, or only when parties named in the oral are in question?
So I want to make sure I understand. If you go to federal court to get an injunction to stop the enforcement of my order,
Yep.
and if you name the parties to this lawsuit in that lawsuit, would my order apply?
No, sorry. I didn't mean to be confusing. If the injunction that I seek is only naming, say King County Superior Court, are you requesting that I file a motion for leave on that as well, or only when I name the defendants?
Well, I can't really speculate about what that lawsuit would look like.
No, it just petition for injunction.
Right, but I don't know who you're going to name in that action. If it were just King County, I'm not going to sit here and say that my order wouldn't apply. It would depend on the claims that you're actually asserting in your complaint. Just because you caption it as against King County, but then you make
now the order so broad that even if I have
Mr. Benchoof, I'm explaining.
How big is it going to get, Your Honor?
Mr. Benchoof, you asked me a question and I'm explaining. Because you will caption, you have a track record, Mr. Benchoof. You will caption a case one way, but then when you look at the actual complaint, you're actually claiming something different. And so if you identified only King County as a party, but then you asserted claims against all the defendants in your complaint, then my order would apply. My order applies to any litigation you bring against the protected parties, regardless of how you caption it. You could caption it against Mickey Mouse for all I care, but if you're bringing claims against all of the protected parties in the complaint, it won't matter that it's just captioned against Mickey Mouse.
For clarification, Your Honor, I mean, I'm just a pro se litigant with a high school education, but my understanding is an injunction under FRCP 65, it has to specifically name the parties being enjoined. So is it the court's position that even though an FRCP 65 petition for injunction is required under the federal rules to specifically name the parties being enjoined and the specific acts being enjoined, and even in the event that I'm specifically only asking for the federal court to enjoin King County Superior Court from enforcing a void ab initio order, is the court's position that if I even mention the parties in there, that somehow this oral also applies? Is that the court's position?
So, Mr. Benchoof, what you're doing right now is asking me for an advisory opinion. If I do, no, Mr. Benchoof, Mr. Benchoof, what you're saying is, if I, Mr. Benchoof, do something in the future, am I going to be in violation of the court's order? And the answer is, I don't know. We'll have to see. I can't give you an advisory opinion.
Objection, void for vagueness. I asked you a very specific question about specific terms, and you're playing word games. So
what I'm telling you is
for appeal.
That's fine, Mr. Benchoof. What I'm telling you is I'm not allowed to do the very thing that you're asking me to do. I'm not allowed to give advisory opinions. I'm not allowed to tell parties, if you do something in the future, here's how it's going to play out. I did not ask for advice.
I asked about the specific terms of what you're alleging you have the authority to do. So I note my objection for appeal. Thank you very much.
All right, Mr. Benchoof. Mr. Tracy, Mr. Russ, will you be able to finalize the order?
We can, Your Honor. One more point of clarification on the drafting. Does the $250 per day per person apply to each lawsuit? In other words, it's $500 per day if he does nothing, but if he files one motion, it'd be $250 per day. Am I understanding that correctly?
250 is intended to be the total. So if he only partially complies and he doesn't comply in the other lawsuit, the maximum is 250 per party per day.
Okay.
And if he doesn't comply, if he doesn't comply in both lawsuits, same thing, 250 per party per day.
So there basically are two conditions to compliance: motion in both lawsuits or dismissal in both lawsuits. Am I understanding?
Correct.
Okay. We'll write that up.
All right. All right. I do need to get to my next matter. I'll look for the order once it's been finalized. I'll get it entered. That concludes this matter. Thank you.
Thank you.
Case in general and how you represented yourself, whether or not there were trials, whether or not the other side had a lawyer, how many times you went to court, the nature of the cases. Case in general and how you represented yourself, whether or not there were trials, whether or not the other side had a lawyer, how many times you went to court, the nature of the cases.
Let's see, I represented myself. I tried presenting a motion in Seattle Municipal Court. The judge refused to hear a hearing regarding the fact that the defense had destroyed all of the exculpatory evidence. The judge was far more interested in reading the newspaper, and I think for his own amusement wanted the case to go to trial. I was found not guilty. None of the civil litigation actions that I've initiated in federal court have reached the trial stage yet. In the 4 cases that are still ongoing and the one that was just dismissed with prejudice by a prejudicial judge, I've been suing numerous public officials. And Davison, numerous settlements for judges. I've been suing Judge David Keenan in one lawsuit that was dismissed, which Judge Whitehead is essentially run cover for. My understanding is that Judge Keenan was actually assigned to this hearing today before he recused himself. This is a similar pattern of behavior that I've seen in Seattle Municipal Court, where they haven't had jurisdiction. I've pointed it out to them, tried to sincerely resolve things amicably, and there's an ongoing pattern of retaliation against me that constitutes a RICO enterprise, which is one of these civil actions that I pled in case number 2:23-CV-1392-J&W, which is now on appeal at the Ninth Circuit, which I can provide the case number for if you'd like.
Mr. Benkoff, have you talked to Mr. Coatsworth, who is your appointed attorney at all?
I don't know who.
So the person standing next to you is Mr. Coatsworth. He's a public defender. He's been appointed. And have you talked to him at all?
We have.
Okay, and have you tried to give him a chance to be able to explain to you what's going on and how we could possibly help you?
Well, I explained to him that I have explicitly in writing, repeatedly with phone calls, emails, and text messages, told the Department of Public Defense that they cannot file notices of appearance to try to represent me, that they're violating my right to represent myself. And yet this continues to happen. And so I made it clear to Mr. Coatsworth, that's his last name correctly,
yes,
that I'm representing myself pro se. And my understanding is that somehow the automated software for the DPD does this. It's not his, he's not directly liable for that. But I've made it clear for days now that I don't want this to keep happening.
I understand, and I think Mr. Coatsworth is probably accurate with that this is sort of an automated process that occurs. It is your right to represent yourself. All right, so Mr. Martin and Mr. Coatsworth, what I am going to do right now is I'm going to order an evaluation under 1077. Given some of the responses of Mr. Benkoff, I do have a concern about his capacity to proceed. Do either of you want to be heard on the court's sua sponte motion for that?
Not from defense, Your Honor. Not from the state, Your Honor, and my apologies, I actually didn't put the case on the record. This is State of Washington versus Kurt Allen Benshoof, 24102680-7 Seattle designation, David Martin on behalf of the state of Washington. And I'll defer to court.
So Mr. Benzu, what I'm doing is I'm ordering an evaluation at this time. It is still going to be your right to represent yourself, but I first need to have things evaluated for your mental health to make sure that you understand these proceedings.
I object to the delay of game. There's nothing wrong with my mental health.
And that may be accurate, sir. It's just some of your responses have struck me as paranoid, quite frankly.
Oh,
And so I
are you-
have to be sure that I am doing the things that I need to do.
Objection. The simple fact that I say that I have factual evidence of an ongoing conspiracy, like you may think that no conspiracies happen, but obviously criminal conspiracies happen, or you wouldn't have laws such as 18 United States Code, Section 1962, Civil RICO. We wouldn't have criminal conspiracies such as RCW 98.28.044, I think it is. So the mere fact that I have alleged in court in other cases that there is a criminal conspiracy, that does not rise to probable cause for you to suggest that there's anything wrong with my mental faculties. And I take offense to that. And I object to any further delay based upon that presumptive and pejorative opinion that you stated.
I do want to add that part of it is also my reading of the certification of probable cause in this case and the circumstances surrounding the charges that you are facing.
Okay.
It also gives, we're not going to argue about this, sir. I'm telling you that I'm ordering an evaluation. We will have a return date of July 31st. Okay?
Object.
You
Note that for appeal.
Absolutely.
July 31st.
July 31st.
July 31st, Your Honor.
July 31st for a return date. Okay. And so that'll conclude the hearing.
Thank you. Happy Tuesday.
Thank you. Please, Brad.
We'll put you back.
Yes.
You can get a date in 30 days.
If possible, Your Honor, could we set this out past August 20th? The attorney of record is in trial the week before the 20th.
Okay.
Council, does August 26th work?
Yes.
Okay, that will be 8:45 in courtroom 1003.
(1003)
Correct.
Thank you.
Okay, and the expiration will be November 22nd.
Thank you, Your Honor.
Okay, that will conclude this matter. Have a good day, council.
You too, Your Honor. Thank you.
Okay, are we ready on the next case?
Yes, Your Honor. Next matters we can call are the Kurt Benschoof matters. These are cases number 676207, 676175, 675405, 656748, 656749, 669329, 676463, 676216, 676492, and 671384.
Okay, counsel?
So I'm the only counsel on this case, Your Honor, and pro se Kurt Benchu. There appears to have been an error on the part of the Department of Public Defense by which Mr. Reagan, Roy, I believe his name is, was a notice of appearance was filed on his behalf in case number 675405, despite my repeated communications by phone, by text, and by email to senior management at the DPD to demand that they stop assigning attorneys to my case to violate my rights. So I'm not pointing any fingers or blaming Mr. Roy, but the notice of appearance filed on his behalf was inappropriate and illegal.
Well, no, not illegal. Because everybody has a right to counsel. And so because of that, attorneys are assigned to individuals who qualify as needing assistance if they can't afford an attorney on their own, or they want to proceed pro se. Mr. Bishop, you have quite a few cases.
I have objection. I have quite a few malicious prosecutions.
Okay, so no, I'm not going to characterize them as that, but if you'd like to, but I'm just saying is you're facing quite a few charges, and Mr. Roy, our DPD, might not be aware that on the majority of your cases that you have been representing yourself. So with that being said, is I will allow Mr. Roy to withdraw, to put in a notice of withdrawal, and we will continue to handle your cases because, as I said, the majority of the time you have represented yourself. Okay, so Mr. Roy.
Just to be clear, Your Honor, does that mean Mr. Bench's request to go pro se on that case is granted?
Is granted, yes.
Thank you, Your Honor.
And Mr. Benchu has gone through the colloquy. He has been very expressive. He has represented himself in front of me several times on his other cases. So I know he is aware of the colloquy on when not wanting a counsel to represent, and that he feels confident that he can represent himself. Am I correct, Mr. Benchu?
I believe so. And so am I correct in my understanding that the court acknowledges that I am competent to proceed based upon past litigation?
Yes, because you've gone through the colloquy before, understanding where the judge asked you, do you understand about this case? Do you understand you'd be representing yourself? You're expected to act as your own attorney. You will not be given assistance. Do you recall that, or do you need me to go over?
Oh, I fully recall that, Your Honor, and I would note for the record that there is a serious contradiction between this court and King County Superior Court, because just yesterday I was prevented from proceeding pro se when the judge claimed that I was, that she had concerns that I was mentally incompetent, and she delayed the case another 14 days until the 31st, and allegedly is ordering a mental health evaluation. So there is, there's
her perception of
no,
we don't have to. We're in a different court. We're both independently elected judges. I'm very familiar with you. I don't know what her familiarity is with you. What one judge decides does not impact what I decide, depending on what stage we're at, but it's particularly that Superior Court, this municipal court. So with that being said, as long, I have not gotten any indication that you are not understanding. The law allows her, if she believes that you may not be able to represent yourself, to do what we call a 1077 and have a competency hearing where you would then be interviewed by a mental health evaluator. So that's her process. So now, since you are finally here and you have these cases, how would you be proceeding on them?
Well, first I'd like to address the two initiating cases, 656-748 and 656-749, both of which are a flagrant violation of the Civil Rights Act of 1964.
Okay, I'm not trying to be rude here. Okay, you know, Mr. Bensher, this is not the hearing for this.
Actually,
we are, no.
Jurisdiction is a threshold matter, Your Honor. You know that, I know that.
Stop, Mr. Bensher, I'm not going through this with you. I'm trying to tell you, this is not the hearing, not that you can't make that argument. This is a.
It is.
Okay,
Jurisdiction is a
no,
threshold matter. These are
okay,
malicious
Mr. Benshoot.
prosecutions. I came
Okay,
down here,
Mr.
excuse
Benshoot,
me,
Mr. Benshoot,
excuse me.
stop. No, it's not a stop. I am the judge. I'm trying to tell you, we are not gonna argue about jurisdiction today. It's pre-trial hearings.
I'm not arguing.
No,
telling
I'm trying to tell you
facts.
is.
I came down here to remind you that you don't
No.
have jurisdiction. I came
Mr.
down here-
Benshoot,
No, let me
Mr.
talk. I
Benshoot,
waited in
Mr.
jail for
Benshoot,
14
no,
days.
no.
I have
No,
had my
no,
religious
Mr.
rights violated.
Mr.
I've been
Benshoot, if
denied
you,
phone
if you
calls from
have
attorney.
arguments, this is not the hearing to raise constitutional.
You do not have
arguments.
jurisdiction to speak. I will let you speak when I'm
Okay,
done talking.
well, no,
If I
that's not
understand
how
what you're
this
saying.
works. I do
So
have
first of all, in
jurisdiction.
case number
Mr.
656,
Benshoot, we've
748,
concluded
and
this hearing.
656,
We've concluded this
749,
hearing.
this
Mr.
court was
Benshoot, we are
prohibited from
concluding,
proceeding against me.
we
I
are
will
concluding
cite
this.
several Supreme Court cases.
We are concluding this hearing because you've decided you are the judge and
No.
that you are moving. I've tried to tell you, this is a pre-trial hearing, no motions for dismissal or lack of jurisdictions
Okay,
happen
and I'd
at
like to-
pre-trial
I'd like to
hearing
note
calendars.
For the record, certain
So
conditions in the
hold
jail
on.
that are violative of my
Hold
due
on,
process
if you
rights.
would let me talk, I'm gonna try to tell you very politely. Pre-trial hearings are either to set this matter for trial or to continue it while you still do investigations and negotiations with the prosecutor's office. If you set this matter for trial, then we will set motions hearings. At those motions hearings, you can make the argument of lack of jurisdiction by the court, lack of constitutional, and lack of constitution in whatever area you think that we're violating the Constitution and other matters. This is not the hearing in which the court will consider lengthy, long, ongoing motions hearings. This is not the time. So the question I have for you before you begin is, are you either setting these cases for trial, so you can therefore then make those arguments, or are you continuing because you need more police reports, discovery, or to negotiate with the city on these cases?
I offered to negotiate with the city. I offered that if they would stop the malicious prosecutions and the RICO enterprise and stop violating my rights, that I'd be happy to do a global resolution. I offered that repeatedly to Dallas Lake Pierre, who was representing the city in case number 2:24-CB.
That is a civil matter.
I understand, but in that civil matter, there were criminal law violations alleged and evidenced perpetrated by Katrina Allen, Sahila Serafan, and others. I won't mention anybody that's in this courtroom. So there is no need to set this for trial because the court doesn't have jurisdiction. I don't have any more need to do investigative work. I have all the facts of what's been going on. The court does not have jurisdiction. The prosecutor is engaging in a malicious prosecution. And it's noteworthy that neither Ms. Katrina Allen nor Ms. Sahila Serafan are here. They're both defendants. I caught them red-handed in perpetrating this RICO enterprise. The court does not have jurisdiction for the quote-unquote trespass cases and Supreme Court case law. There's no question. In fact, it's laughable. This court has proceeded in maliciously prosecuting me in those cases for nearly 4 years. As far as the DV cases, which are all the other ones, this court never had jurisdiction because under RCW 7.105.050 subsection 1, parts A and B, only King County Superior Court could exercise jurisdiction in the alleged violation of the allegedly valid restraining order that was issued by Judge Keenan. This court also violated the priority of action doctrine. When another court asserts jurisdiction, they have jurisdiction. That's also what happened when King County alleged that they had jurisdiction in the family court proceeding. I have shown in court over and over and over again that the mother of my son, along with her prostitute perjurer girlfriend, they committed perjury, foundational to Beatricely initiating case number 21-5-00680-6.
Okay, so Mr. Bishop, not trying to cut you off, but I am not gonna base a ruling. Since I am a defendant in your action, I'm going to recuse myself from hearing anything further because you're bringing in that civil matter which you have named me as a defendant. We're going to try to find a judge who has either has not been identified as a defendant in your civil case or has not had your case yet because the circumstances of which your cases have moved through this courthouse. So at this time, I'm going to stop, exclude speedy trial. We're going to get you a date, and then I'm going to try to find an attorney who will not have any bias or anything else in regards. Okay.
Your Honor, I did just want to note that this was going to be a city trial set, but given
He's
that-
not, if you're, it doesn't matter what the city is going to do here at this point. He does not want to set this matter for trial. He believes at this point that the court should make a ruling on his arguments. The court is not making any rulings. The court is recusing itself because I am a named defendant in the civil lawsuit. So basically, all I'm doing is punting it to the next judge that we can find.
And Miss, I don't know his name is Miss Prosecutor. Yeah, are you aware, sorry, I didn't know your name. Are you aware that a motion for removal to U.S. District Court has been filed under 28 U.S.C. Section 1455 to remove all of the cases in this court as well as the contempt?
That's a civil matter. She's a criminal prosecutor. She's probably not aware. If I'm wrong, counsel, am I wrong? Are you aware of the civil lawsuit that I'm referring to?
I have no idea of the.
I was actually referring to a criminal removal under 28 U.S.C.
She's not familiar with all these. She does not practice except for in this court. Mr. Benshu, I'd ask politely that you not bring her in because I'm not making a ruling. She's not been on your cases before. There's no need to bring one more person into this situation. You've already identified prosecutors you believe have violated your laws and cited them in your lawsuit. So she knows nothing. She's not participated in anything. And at this point, she's not participating because we're not setting this matter for trial. We're going to get you a new judge and get you a new court date.
How far should we set this?
Couple of weeks, because he's in custody. Let's try to get something, but we need enough time to get a pro temp, so at least a week.
A week, okay.
For the record, I wish to note that I've been denied all pro se materials. I've been denied phone calls to find an attorney or to speak with an attorney in private, as is my right. I've been denied pencils, paper, access to computers. My religious rights have been violated. I've had to choose between having my religious freedoms protected under Article 1, Section 11, and my right to appear in person under Article 1, Section 22.
So noted.
On the 24th or?
That's fine,
Okay.
if that's a free day for all these cases.
We'll set all matters on July 24th, 1:30, back and forth 11:03. I'm sorry, you said July 30th? Or July 24th? 24th, okay.
And I would note for the record that the ongoing malicious prosecutions are a violation of 18 U.S.C. Section 1512. My religious computers and documents were seized from my home without a valid search warrant, and these prosecutions are clearly intended to infringe upon my right to petition for redress, as I cannot litigate any of the court actions that I have ongoing presently in state and federal courts.
Okay, thank you, Mr. Benshaw. We'll see you back on that court date. It will not be me, but someone else.
Okay, happy Wednesday.
Okay, do we have any other matters that are ready?
Yes, Your Honor. The next matter we can call is the Jonathan Nguyen matter. This is case.
So is he self-represented?
We don't know.
I think that's why people were in here.
Oh, okay.
I don't know if you filled the actual pro se thing but that's what the case was. We'll go over it. I don't think his thing on there says pro se. Don't you have to like fill that out every time? You have to fill that out every time, Lynn? Pardon me? To be a pro se, even though like his last time he was pro se. Waiver of right to counsel. You have to fill that out every time, right?
No, I don't think so.
Every time? Every time he gets a.
I think we can handle these matters. I don't think he's represented.
So he does have,
Standby counsel?
Yeah, because I do believe he's going through
be pro se.
comp proceedings.
He's in comp proceedings too?
Yeah.
Is he?
Oh,
That's
I
what,
don't have that.
I don't have that either.
that's what my notes say from the.
I know he was previously. I don't know if that's been updated, but we can take a look and find out.
Yeah, I don't see, I'm looking through my notes. I don't see any 1077 order.
At least based on my notes from yesterday, it says that he's going to a comp eval.
As of what day?
In what jurisdiction?
Yeah, is that King County like Superior?
Yeah, let me read the whole name. Yes, in county.
Okay.
Oh, yeah.
So that doesn't necessarily apply to us. He looks like he's got DPD assigned.
Yeah, we did assign him.
So does he have a counsel of record at this point?
Yeah, Reagan Roy.
Reagan Roy's not with is he still with the office?
Yes, but after last week, I don't know.
Okay, how about this? Can we reach out to Mr. Roy? See if he can pop in, let us know what his perspective is. We'll hold off on doing anything on any of Mr. Benshoof's cases until we give them an opportunity to see if standby counsel can fill us in. If he's in 1077 in county, that doesn't necessarily apply to our cases, although it's likely relevant.
Your Honor, I don't see that he has counsel.
I see he's got counsel on the last two cases, but those might be review matters. So actually, let me just see if there's a notice of withdrawal.
What's the one of the case numbers?
One of the case numbers I see is 675405. I think that was a case that went to. I get an NOA signed 2/12/2024. Then I got a withdrawal. You know what? I don't think he's got counsel on this case. Okay, let's just see if Mr. Roy can pop in. If he can, great. If he doesn't pop in. No, never mind. You don't even need it. You don't even need to. He's got it. He withdrew, and then I see Ms. Sirkin.
Oh yeah, he withdrew on the 22nd on the 405. The one ending in 405. Yeah, that's a lot.
Yeah, so he withdrew, but it's a substitution. So then we have just no attorney listed.
But we also don't have pro se paperwork.
One of his cases,
On one of them.
there's like pro se.
I wonder if that's why I refused to fill out the routes. It's linked.
I see Crystal White listed as an attorney. She's not with the office anymore.
I feel like as of not Phil. So as of last, what was the 16th? As of last Tuesday, he was in here, Your Honor. Reagan Roy was in here, but after the whole shebang, I think he withdrew.
So Mr. Roy withdrew, so we don't believe he's represented.
No,
Okay, well, if that's the case, then
and I think because he wanted to be pro se.
okay. All right, so then I think we should call these cases, and we'll just need to set this over.
All right.
So
let's go ahead and call them.
Yes, Your Honor, came to vote for the city for the record. We're gonna be calling the city versus Benchoof matters. Those are cause numbers 676-207, 676-492, 676-463, 656-748, 675-405, 656-749, 676-175, 676-216, 669-329, 671-384.
All right, Mr. Benchuk is in custody. He has declined to come to court today. The court staff and I have looked through this. We can't find an attorney of record. The court does believe that there's competency proceedings going on in a different jurisdiction, which doesn't necessarily apply to these cases. At this point, Mr. Benchuk has plenty of speedy trial left, but he did refuse. So what we're gonna do is we're gonna set this over. Let's find a time, lower bench, in the next, either later this week or early next week, where this case can be heard. We'll make this an excluded period for the purpose of speedy trial and all cause numbers for the defendant's refusal to come to court. And we'll maintain bail on all cause numbers.
Yeah, because I think these are all DVs.
Okay. And because there's so many judicial officers recused, let's make sure we're not sending it into a courtroom where somebody's already recused themselves.
Yeah, I know Judge Jess has recused herself.
It would have to be DV, and they're just gonna have to clean the judge.
Okay, then do that. Yeah. Whatever's not going to make the clerks angry, that's fine with me. I'm going to step off the bench very briefly. We're going to stay in session. Y'all don't need to rise. I'll be back in 1 minute. Just keep working on that courtroom. I know it's going to take a second.
If he hasn't, so it would have to be DV, so, it would be.
Hello?
Or 11:03 on either Tuesday or Wednesday.
Tuesday, Wednesday are 11:03.
Yeah.
I don't know how to. 11:30, right? Okay, so then 11:30.
Hello?
Yes, this is the bailiff. Who's speaking?
Henry Walker. I was trying to see, I heard him say something.
Yeah,
Was
go
it
ahead.
in the courtroom? I was just trying to see if it wasn't me.
Mr. Walker, we haven't quite gotten to your case yet, so we're gonna go back on the record. You can just hang tight and be patient. We'll get to you, okay? I'm gonna
I was
put
trying
that, huh?
to courtroom.
I'm sorry?
I was trying to make sure I was in the correct courtroom.
Yes, sir, you are.
Okay, thank you.
Okay.
Okay, Your Honor, so we can set all those cases for next Tuesday, which is July 30th at 1:30 back in this courtroom, 11:03.
All right.
Is that at 1:30, you said?
Yes. I'm ready if you're ready, Your Honor.
All right, just give me a second. All right, I'm ready for the next one.
I mean, we actually don't have anything ready, Your Honor.
Oh, okay, great. Are we waiting for attorneys?
I believe so.
Who are we waiting on?
I know Miss Miller said she was gonna come back for a case. And I'm not sure who the defense is on the other matters.
Okay. Oh, we can go off the, we're already off the record, fantastic. We'll just hang tight.
All right.
So Miss Miller just messaged me and said that she can come back.
Well, let her know we're ready.
Not even like, Your Honor, I haven't seen this.
Shigera? Okay. What is it? What are we doing on that? Okay. Whenever the court's ready, we can call on the matter.
I'm ready. We're on the record, go ahead.
For the record, Carrington Bill for the city. Next matter is City versus Leisure, cause number 424-000.
Afton Lewis appearing on behalf of the city.
All right, so defendant has refused, is that correct? All right, I'll ask the lower bench, with a refusal, do you want to set it over 1 day, 2 days? This gentleman also has a felony hold, is that right? So he has a lot of holds.
Thursday calendar is jury trial this quarter. Yeah, it would have to be an 11:03 if we do it this week, Your Honor. We can do that if you'd like. We can do tomorrow or Wednesday afternoon at 1:30 and 11:03.
All right, what's the city's position?
Your Honor, no objection, just to setting it over sometime this week.
All right, whatever day this week works well, that's fine.
Then at 1:30 and 11:03.
Okay.
I apologize, Your Honor, Jeanette Storm-Glenn, stepping in briefly as a friend of the court. Does this person not have an attorney?
He's usually pro se, or he was, he's before.
Yeah.
I don't know, I can't see the portal to see.
He doesn't have counsel, and he won't sign the pro se paperwork.
Pardon me?
Attached to 405.
Okay.
I guess I would just ask Your Honor, if you could refer the case to DPD, because if he qualifies for, Mr. Royal one case, then he would qualify all of them. And so I would just ask that you appoint DPD to make sure that he is represented, especially since he's refusing.
Any objection by the city?
Objection.
All right, that will be granted. And do I need to sign this?
So we are appointing DPD right now.
Yes, I guess Reagan Roy represents him on one matter. Do you need me to do anything or?
I'll just make a note of it, Your Honor, and we can go ahead and go back and do it later.
That's fine. All right, lower bench, does anyone need a break or?
No, I'm almost done typing it on the space numbers, so I'll be ready.
A lot of,
If we want to take a break, it looks like we're still waiting on a couple of the defense attorneys to show up to handle the rest of the matters.
right, well, why don't we go off the record for now and
I'm just trying to see if there's more of this, because it doesn't really make sense that they uploaded such a long video with no conversation. I don't know why it's taking so long to load though. Very buffery. I just want to see. I'm going to switch back here to this computer. Just one sec. I just need you guys to let me know if the sound is bad again. Is it this one? No, next one. $621. Okay, let me know about the audio. If there ever is audio. Seriously? They uploaded this whole video of just blank.
we appreciate it. Okay, thank you. Here, we really appreciate it. It's our here, we really appreciate it. It's our understanding you can be excused.
Okay, thank you, Your Honor. So
Thank you so much, and thank you for checking back in.
And that's
Apparently you're not needed at this point,
okay,
so,
that's Morales Mejia, yes?
yes.
Okay,
Thank you
very
so
good.
much.
Thanks for
Yep.
letting me know. All right.
Yeah, thank you. We appreciate it.
Your Honor, we do have that already.
Okay, great. We'll go back on the record.
So I want to recall number 17 again, sorry, 671-578, City of Seattle versus Tornado May. Acton Lewis appearing on behalf of the city, and Attorney Richardson is
My case is like security. Yes. Okay, so it's not on there? Yeah, I should, but not this one. For Dennis. Random. Show me another one. Yeah, okay.
You can go talk there.
Not anyone's. Oh. Now you pass.
What was that orders? Yeah. Second.
Michael?
Yes, you are.
Order to. It has, so there's one step last week, yeah, but it should be debated next week. Oh. Because I think somebody.
Thank you.
See, they don't know what's for it.
You have one approach to this to the cars. You said is.
We don't have.
Sun's out. That was a stress factor, so. Shut off the window.
This is Steve.
That. And then one more. That's what you're. So.
Freeway.
That's right.
Everybody's scrolling.
Thank you very much.
So you said, I'm sorry, so you said this is going to be.
It should be noted on the record. I think we're just. That's also here. So I don't have an OTA yet.
Okay, thank you.
I'll see you.
They corrected it?
Yes, yes. Yeah.
You right? Oh, no, it's on. It's done. So, I need to okay, this one already has a line in which the order to check salvage.
It's gonna be bench shoot matter for now. I'm ready to. Ready. This. So it's a bench shoot. Yeah. Okay. And up next, runners, we're gonna hop back on the motion calendar. It's gonna be bench shoot matter.
This is State of Washington versus Kurt Benshoof, 241026807, Seattle destination, Gabrielle Charlton State.
And James Coates requests defenders, attorney of record in Mr. Benshoof's matter.
This is on for a competency returner. I understand that they refused. Defense counsel had wanted this on record. I should note Judge Kuhn is refused from this case, which is why it's on this calendar. We are still waiting on a competency report. And so we're asking to continue this to Monday at 1 p.m. This courtroom. That works with the court.
And the only record that I have to make today is that I do not have authority to agree to the continuance. Mr. Benshoof does not agree to the continuance, and that's sort of where we stand in the case. I also don't have permission to appear on SB app. However, he was aware that we had one today and refused to.
Okay. It will note that, as you remember, Ms. Benshoof, clearly, he had wanted to go per se at arraignments as well. I'm the one who ordered the competency evaluation, so it's finally given some of his responses at the arraignment hearing that suggested that perhaps there was a mental health condition that made it difficult or impossible for him to with counsel. Given all of that, given the fact that he has refused, and I appreciate, I do think Mr. Coates was correct in trying to run the record today because Mr. Benshoof is very happy with the entire proceedings. And he should be present to know what's going on. Should he's chosen not to come today, I can't make a competency determination without evaluation or without Mr. Benchief. So I am going to go ahead and continue it till Monday, where hopefully we can address this whole issue.
And Your Honor, I would just note for the court, and that probably answers part of my question. We still need to enter conditions of release, even with competency pending, in the event that he were to pull out.
Right, I understand, but we will need him.
Yes, of course, yes.
Okay, all right, thank you.
And up next, Your Honor, it's going to be the Malone matter, and pop back on the omnibus calendar. It's going to be numbers 40 and 41.
Before we watch the last video that is currently available, there is a poll up. So this guy's friends have been representing themselves pro se on a property dispute. Then there's the Hutch jewelry trial, which has finished, but I saved all of it. A lawyer accused of assassinating someone is the gist of it. We didn't watch all of Judge Fleischer last week, so we have that as well. Or there's general court. You basically have under 12 minutes-ish to decide.
'21, '22, '23, '24, '25, '26, and '27 matters. Those are case numbers 676-175, 671-384, 669-329, 676-216, 656-749, 675-405, 656-748, 676-463, 676-492, and 676-207. These are the Kurt Benchief matters.
Good morning, Your Honor.
Morning.
Boy with DD. Just so the record is clear on all of these cases, I'm appointed to case 676-463, 675-405, 676-216, 676-175, 671-384, 676-492, and 676-207. Previously, with regards to case 675-405, Mr. Benchief was granted his pro se motion, so the portal indicates that there's a notice of withdrawal. However, still appears that I enlisted as attorney of record for that, but I have the attorney of record for the other cases that I just said. For the court, I do not have the report authorization to do anything or address these cases.
Okay. Just as a preliminary matter, so Mr. Roy, if okay, so I know that, okay, so I'm looking at my screen here. So you've noted Mr. Benchief is per se on 656-749, but would it make sense for the court to direct appoint you on, it looks like there are two cases where no counsel is, let's see, that would be 669-329 and 656-748. I don't see any counsel noted. Would it make sense to appoint you so that you have, or would you try not to?
I do not have his authority for that, Your Honor.
Okay. Okay, I understand. Okay. All right. So, okay, so the court understands that these are all pretrial cases, correct? Is that right? Okay. And that Mr. Benchief is in custody and is refused court today. Mr. Roy, just another question too that perhaps you can or cannot answer. The court had some information that perhaps that competency was raised as an issue in another at King County Superior Court. Do you know anything about that?
Yes, Your Honor, that was raised sua sponte in King County Superior Court.
Okay.
And I believe that there has been a finding of returning of
Oh, okay, okay, thank you. That's helpful. Okay, so at this point then, City, what would you like to do with, what do you suggest we do with Mr. Benshouf's cases?
The city would just ask that the court, have a short set over for these cases and exclude any time between now and the next court date.
Okay. Okay, now I wasn't able to go through each of these in detail. I think that makes sense to set these over and exclude time. Are these all on the same time for speedy trial calendar, or are they all different? I guess, Mr. Roy, do you know that offhand?
I do not, Your Honor.
Okay, okay. I'm sorry, Madam Clerk?
So they'll have September 3rd as speedy expiration.
As expiration September 3rd? Okay, I'll have to, okay, so let's do this. Okay, so there's an issue here where I believe that the other judges have had to recuse themselves, some of the pro tems as well. I, at this point, can still hear Mr. Benshouf's cases, so I don't know if I have a choice except to set these. Let's see, Laura Bench, what is our Monday? Let me just see what our Monday pretrial calendar looks like, because this, yeah, I'll take a look too. Mr. Roy, did you have a preference on the new date?
I do not have a preference, Your Honor.
Okay, thank you.
Yeah, August 5th.
Yep.
Yeah, 26 out of 29 cases.
Okay. All right, so I'm going to, let's see, give me just one more moment, please. Okay, I'm wondering if it would make sense to set them in the afternoon instead. Mr. Roy and Mr. O'Brien, if I set these, because it's such a big number of cases, my pretrial calendar looks pretty full on Monday morning. Right now I've got 2 contested revocation hearings for the afternoon. Would that work for both of you if I did that instead of setting it in the morning?
That would work for the city, Your Honor.
Mr. Roy, would that work for you? Okay, all right, Laura Bench, let's do this. I'll do a special set all of Mr. Bench's pretrials for August 5th at 1:30, please. Okay, and then the court is going to exclude time. I'm going to need to look at these more closely and figure out exactly where that puts us. Okay, so Laura Bench, do you need some time to do this? Okay.
Madam Clerk is gonna help me, so I can move on.
Okay, very good, thank you. Okay, let's see, Mr. Roy, was there anything else, or Mr. O'Brien?
Only thing from me, Your Honor, just so the record's clear here.
Uh-huh.
The case the pro se motion was granted on was 675-405. That's all I have.
Okay. You know, Mr. Wright, I have Mr. Benchu pro se on 656-749. Is that not correct? And then I have you representing him on 675-405.
So when these cases were first back on warrant status, I was only assigned to one, and that was 675-405. And when that first hearing happened, Mr. Benchu's motion was granted, and I was withdrawn from the case. And I believe that I was appointed to several other cases after that, and that is why I am appointed to the other cases here.
Okay. This is very confusing here. Okay, can you just, okay, I'm sorry, we might be talking in circles, but can you just, so from your perspective on 656-749, what do you believe he's pro se, or that you're representing him on that one?
I do not have noticed that I've been appointed today.
Okay, all right, okay, so I think that he is. Okay. All right, but, okay, in any event, yes, the court is excluding time from all of the cases, whether or not Mr. Roy is representing Mr. Benchuf on these, because he is not here today and there's no 3-4 authorization, so, okay. And as I was saying, I need to go back over these to figure out where we are exactly with expiration. It might be helpful if the parties want to do that, do their own calculations as well, so we can compare. I will try and have that information for Monday. Okay, all right, and so we'll go ahead then and conclude Mr. Benchuf's cases at this point. Thank you. Okay, Mr. O'Brien, you want to go ahead, please?
Yes, the next matter we are ready to address.
Okay, so Hutch Jewelry Trial 1. I am just looking for how to redirect because it's not coming up. There we go. But what I'm going to do as well is, how many tabs is the normal amount of tabs? Just want to go to my channel, live, share. In case you don't get redirected, here is the link. Okay. Right, everybody, hang tight. I'm going to send you over. If you don't get sent over, the link is there in the comments. You can click it and it'll take you there. Okay, let's go.